matters that you must be decided. At least for me, I do not find it that simple.
By 100,006 Act has ever flood an execution proceeding has been initiated, which is unheard. Service has been recorded by the court below as well as by my lawyers coordinately. Absolutely incorrect. Take responsibility. The service of execution proceeding has been recorded and you know the learned trial judge has said that I could not prove.
Have you filed an appeal from the award?
No,
I'm asking you whether you have preferred any appeal from the.
No appeal has been filed.
One, I'm asking you.
Because unless I get the award from the arbitrator directly, your section should not lie. That means the recent dictator of Honorable Supreme Court. The arbitrator has to serve the award upon the party. The award was not served either upon the party or upon the limited. Upon none. We came to learn about the award only upon getting a notice as regards the execution proceeding.
So you could not ask for a copy.
They have asked, we have not been favored with a copy. Unless you are favored with a copy, section 24 application would not lie. My lord, you kindly come down really on me any single statement made by me will be factually incorrect. Any single statement. After my lord, finishes, I will just submit one sentence.
When do you want the matter?
15th is the date. In my registered office is sold off. I have 4,000.
What is the last order passed?
The last order, resolution of
What is that? I do not know.
Be appointed, and it's a long process.
Yes, so what is the harm? Let it come in the list.
On
one day only, on 15 itself, everything will be over.
The terms of sale would be fixed and the date fixed for sale of the property. Then we are by law will be bargained with another judicial application which is required to stop. Then another order will be passed, another judicial application which is required to be filed.
So once the court has declined to pass an interim order, I will just be forced to take up an interim the entire hearing.
But this judicial application can be disposed of within a short while, this can be disposed of. The point is very short and simple.
What is the point?
The point is whether the award has been solved or not. If the award has not been solved as required under the Act, whether execution proceeding is not arbitration proceeding. At the first, this is nothing but an arbitration proceeding. It's an order by the Specification Council under the MSME Act of 2006. This is the award of the petition. Lastly, before the petitioner coordinate bench has passed an order, we are saying that this is nothing but an arbitration proceeding depending upon the previous fixture of the Honorable Supreme last month. We are represented by
Or keep it to the 15th.
I'm so grateful. Okay.
So everybody's matter will take 2 minutes. Release it or not either? Why release? All right, you want it. What can I do? If it comes, I will give it. Is it pending somewhere? Give it on Monday. Expeditious dispose on one. If you mention today also, we will not send requisition paper next week. So give it on Monday. No. If I allow that, that means I cannot set a trend or a system that mentioning will only be allowed in the first 2 days of the week. All right, call the list. All right. If I allow you, then many senior advocates I have turned down, saying that come back on the next week and accepted the procedure followed by the
but subsequently they refused. So it is in
One
ad
minute,
interim
one
stage.
minute. Defendant number 1 died. You have to take out an application for
Yes,
substitution.
we already have filed an application there, and that application is pending. Your Lordship will find in the second paragraph of the order. That application was not heard, and the
So
one,
opposite party numbers 2 and 3 ke korte hobe.
yes, Your Lordship. The 3 is not yet party.
So Orijit Ojha is dead.
Orijit Ojha is there, Devashish Malik is there, but
Is he alive or dead?
alive, alive.
Well, all the opposite parties. But the point is that the court has to be satisfied that there was a violation. That is there.
Definitely, court has to be satisfied, but that is
that
not
co-
the ground. The ground it has been
You
rejected.
have to direct rehearing of that. Yes.
Gratefully.
5 নম্বরটা আজকে তাহলে 5 নম্বরটা নান অ্যাপিয়ার্স করে ছেড়ে দাও অন ওই কথাটা থাকবে না 12 এ থাকবে লাস্ট চান্সটা কেটে দাও new matters have been filed why are the people not coming missing they are missing it they're probably thinking that it is yes sit
Can you give me a short particular of 15 to 20 minutes, my lord, or fix the matter at 2 p.m., my lord? Actually, my
yesterday I was
yes, my
making
lord.
it, not
This
this
is a
week.
very urgent matter, my lord. My certainly my conducting advocate of the petitioner is on stand on list on the division bench. My lord, kindly give it 15 minutes.
So if he's every day in the division bench, then
My lord, kindly,
that's why I wanted to adjourn it.
that is why I have not
Come back at 12 o'clock.
12 o'clock, my lord.
Who is your learned conducting
My
advocate?
lord, advocate Partho Chakraborty.
Yes.
Nine, my lord, in this matter, my lord, I am appearing for the defendant petitioner. What happened, my lord, the opposite filed a suit. I appeared. As soon as it is for recovery of position, in such a suit, my lord, such a put up petition was filed for withdrawing the suit without giving opportunity of hearing. So for the withdrawal of the suit, I have no objection.
Where is the order impugned?
Yes, my lord, that is at page certified copy, my lord. 21st December 2022. Order number 3 dated 21st December 2022. My lord, got it? Just before the bunch of title suit number 10 of 2023.
Order number?
3 dated 21st December 2022.
Yes, yes.
I got it. Prior to, kindly, if your lordship may kindly consider the earlier order, that is order number 2, where I appeared and filed.
Admission hearing means order 10.
Though it is not required, my lord, but the court order 10, my lord, my lord is looking
No, admission hearing means what?
admission in the suit formally admitted for hearing.
Yes, what is wrong in this?
Yes, my lord. Advocate, the plaintiff is not paid for declaring that the schedule of the property assets wants to withdraw the instant suit. There is no meeting. The plaintiff permitted to withdraw the instant suit as is only with the liberty to file afresh. Now, my lord, what they have, this is done in spite of our objection. So far, this is the point that is rectifiable. It is not. Now, my lord, what they have done, the next page, my lord.
Rectifiable defect.
Yes. So that if he wants, that can be like granting liberty to file afresh, because what he has done subsequently, my lord, 10 of 2023, filed an answer at the higher court by incorporating some other defendants on the same plot of land, same cause of action, and get an order of injunction. So this, my lord, order 23 rule 1, my lord, knows very well than us. My lord, satisfaction whether it is incurable defects or the suit might fail for want of such a defect that is not curable. Mere prayer for omission for seeking declaration does not ipso facto mean that the suit is not maintainable. That is a curable defect.
Yes. So he withdrew and filed afresh.
Yes, I could have understood he filed a fresh in the same court. What he has done, taking advantage of the same, he filed a suit before the Court of London Senior Division. Next page, that's why I have annexed for my lord's satisfaction.
So that order is not wrong.
No,
but
this order is wrong, my lord. Kali consider order 23 rule 1.
No, it is not wrong.
If your lordship Kali order 23 rule 1 once, my lord. At any time after institution of the suit, the plaintiff may, as against all the other defendants, abandon his suit or abandon a part of his claim. Provided where the plaintiff is minor, my lord, I am not. Where the court is satisfied that the suit must fail by reason of some formal defect, or there are sufficient ground for allowing the plaintiff to institute a fresh suit for subject matter of a suit or part of a claim, it may, on such terms as it thinks fit, grant the plaintiff permission to withdraw from such suit or such part of the claim with a liberty to institute a fresh suit in subject matter of such suit or part of the claim. By the plaintiff. So these are the two findings. The suit must fail by the reason some formal defects, and there are some.
If you don't ask for declaration, suit can fail.
Now, my lord, what is the suit for? That's why, my lord. And consider page 20. Simply is a suit for recovery of possession against the describing us as a trespasser.
Where is that prayer?
Page 20 is a plain starts, and the prayer is at page, my lord. 23.
What does it say?
Paragraph 19, my lord, left hand bottom, my lord, will find আদালত এলাকা রসুম বর্ণিনার বাদীগণ পাত্রের অধিকার ট্রেসপাসের মূল্যে বিবাদীগণকে উচ্ছেদ ও বহিষ্কারপূর্বক খাস দখল পাওনার মধ্যে বাজার মূল্য 1,19,000 এত টাকা 51 টাকা তদুপরি কোর্ট ফি আইনের বিধান মতো রসুম দেওয়া হইল। And very interesting, my lord, can you consider
the law is you have to ask for a declaration along with?
No, if my title has been clouded, if there is a threat to the title, then adjudication or declaration is necessary.
No, that's all right. But isn't it, there's a...
He is claiming to be the owner of the property. Yes, 34, section 34. 34, that if you sought for declaration, if you are entitled to ask for some other release, you did not omit to do so, then the suit, such declaration is not permissible. On the contrary, if you ask for declaration and ancillary relief you did not pay, then such declaration is not permissible. My lord, may I clear to your lordship?
So you are saying that this could have been included by an amendment?
Yes. If that be so, there is no occasion because what he has done, because of the next page, my lord will find.
But this suit has to be challenged also, na, on the ground of
There-
subsequent suit.
Unless until this suit is, I can ask for section under section 10. I cannot stop him from filing of this suit, my lord. That I can't. But I can pray for stay of the all for the proceedings of the subsequent suit during the pendency of the earlier. Because in both the suits, the issue is the common and substantial.
So they can be heard analogous.
Yes. That unless until this suit revive, I cannot ask for the same also.
What is your, why are you not, why do you want to have an additional suit? How does it help you?
It is not. I am the defendant.
No, that's what I'm saying. So if this is continuing and why you want?
Yes, my lord.
to
Why, my
revive
lord?
the
If your
other
lordship
suit?
can consider what he has
How
done.
does it help you?
Yes, because of, can you turn to the next order, though it is not the subject matter of dispute, my lord, the injunction granted against the defendants and other from interfering in their position. What he has done, my lord, in earlier he filed a suit for eviction of a trespasser, recovery of possession. Subsequently, suit for declaration of injunction. And he got an order of injunction.
And he doesn't want recovery.
My lord, injunction once granted, then my lord knows how it can be implemented, in what manner.
You contest this. Why are you contesting that order? I don't understand, because you are only inviting an additional suit.
Yes, because my lord, if he is not in position to file a separate suit on the self-same cause of action, then this subsequent suit on the basis of which declaration sought for and for the injunction, that will go. It will be barred under order to rule 2 also.
What?
That subsequent suit on the same cause of action, if he wants that declaration, he can done on the earlier suit also. But
Now that is what he can do is fine, but how are you affected?
yes, because I have participated in the earlier suit, I have disclosed that I want to, without objecting, without my consent, my lord, without giving me opportunity to that aspect, my lord, the suit has been withdrawn because I am representing, my lord, the defendant number 1, 2 and
You
1,
were
2
not-
and 3.
You are not on notice?
No, 1 and 2. There 1, 2 and 3. 1, 2, 3. This withdrawal petition is not served upon us. We filed an Vokalatnama.
But if the prayer for recovery of possession is not there in the subsequent suit, it's good for you.
Good for me, but the injunction is causing difficulty to me.
That you challenge that.
And this application, my lord, this withdrawal application has not been served upon me. Because my application, my lord, your lordship will find paragraph 5, page 6. My lord, can you turn to paragraph 5, page 6 once?
Because if the suit revives or does not revive, you are not in any
No,
harm.
my lord, I'll ask for the not to file a self-same cause of action, that portion. He may file another suit, whatever suits he wants against me. The cause of action which he has pleaded in the earlier suit,
That is because he got the liberty.
that's why. My lord, that I have the right to oppose. I have the right to oppose. That application I have withdrawal, I have no objection. I can't. The plaintiff at any stage of the suit can withdraw or abandon his claim. I cannot. But when he asks for the liberty, that portion I can oppose.
So how can you prevent someone from filing a suit against you?
Yes, on the self-same cause of action, that is the thing. He may file number of suits against me. I have no objection.
So suppose today this suit revives.
Yes, my lord. Then, my lord, can you consider the
So
plaintiff?
you have to contest.
Yes.
So why you want 2 suits?
Why 2 suits, my lord, if your lordship kindly consider? If this suit survives, the subsequent suit on the same automatically goes. I need not to contest there. That will automatically goes.
Maybe.
That will automatically goes. But I am entitled to get an opportunity to contest this application.
All right. Service upon the
1 to 4, my lord. They are the plaintiffs.
opposite parties plaintiffs, and also the learned advocate, as also in the learned upon their learned advocate conducting the case in the court, who was conducting the case. Do you want that? No need.
Yes, because he is the advocate who is
Who is
conducting the
conducting
subsequent suit also.
in the court below. Let this matter appear on 21st June under the heading new motion. Affidavit of service to be filed on the next day.
Grateful to you.
কি গো? আমাদের দেখাচ্ছ কেন? Yes.
In this matter, I have instruction to appear for the sole
There is no
opposite party. I have not
There is no
filed any
caveat.
caveat.
Give him a copy, come back on Monday.
My lord, some more time because my
You have not filed a caveat, you
Yes,
are in
yes.
bargaining position.
no. Only one thing. My client is now residing at Bombay, my lord. Bhokaladana is required. That's why I'm paying.
So Monday, Wakalatamba will come by courier. When do you want? What is the matter
My
about?
lord, order of restoration of possession against this petitioner, my lord.
By
By the trial court, subsequently misappeal failed, thereafter, my lord, disapplication.
Both court rejected his application.
Yes, this is
Against
a-
that,
This is
on
the
contest.
subsequent application.
fight the
My lord, the parties are brothers and sisters.
what
Let
is
us-
the order impugned?
Order impugned is a order passed in a misappeal. There is an injunction,
1 minute.
my lord.
Please sit down. Take your seat. What is the order of injunction?
Order of injunction is at my lord 34. Page 34. Page 34 is the my lord operating portion. My lord, starts from page 32.
Yes.
My lord, my specific contention is on two-fold ground. First of all, my lord, this is the second application of the opposite party which was allowed. First application was rejected. Both the applications are of self-same cause of action. Whether the second application will be barred by constructive res judicata. My lord,
What is the first application? Where is the order in the first application? Where is the police report? You show me that.
police report, my lord, I don't have the copy of the police report. My lord, paragraph 18 of the judgment, my lord, explains everything, my lord.
Says that yes, there was disposition.
No, my lord, paragraph number 18 says he was disposed in the month of July. In the month of September 2022, he took out an application for restoration of possession. That was after perusal of police report, that was rejected as that was refused as misconceived. Subsequently, same cause of action, another application was filed.
Where is that order?
My lord, the order is not, my lord,
Nothing
within
is
my
written,
brief.
then you cannot.
But the observation is there, my lord.
All right.
My lord, paragraph 18, page, my lord, 9, my lord, kindly see.
Where is the order of the trial court?
Order of the trial court, my lord, I have annexed. Page, my lord, 45, 46 onwards.
Sit down.
Where is the order of injunction?
Order of injunction is at page 32, my lord. Page 36 is the first application for restoration of possession. And my lord, page 40 is the second application.
Where is the order? First order?
My lord, the first order, my lord, I don't have. But my lord, it has been observed by the learned appeal court, my lord, in paragraph number 18, my lord. In on page, my lord, 9, certified copy.
Yes.
Both of these are of same cause of action. Second application
You
has been
throw the
ordered.
parents out.
No, that is not my contention. My contention is that I am in possession of the property for 20 years. For 20
Yes,
years.
we disbelieve. Court has said that you have not been able to show a single document which would indicate that that is the property from which you are staying and running your business. The trademark registration does not contain any address. The electricity card does not contain any address. You have not challenged the order of injunction. You have not
That is-
challenged the title deed or the gift deed given to the plaintiff. At this stage, after all this fact finding at 227, what will I do? You contest the suit.
My lord, only on the point, my lord, the second application, whether it is constructive res judicata or not.
No, that is not necessary only. That point will not be gone into at all.
My lord, even
Court
if
has passed an injunction. It is the business of the parties to implement that, and it is a matter of public policy that all injunctions and restraint orders are obeyed by the parties. You cannot throw your parents out and say that this is constructive res judicata. And appeal court found that they are not similar. They are not similar, and it was not decided on merits.
my lord, the fact regarding allegation of dispossession is same.
Maybe.
Both are filed subsequently.
So what?
Now, my lord, on the same fact, whether the second application is even maintainable, my lord. Rest time, my lord, placed before your lordship. My lord.
Take down. So where was he living? The defendant was living in the same
Yes, yes,
premises.
yes. My lord, kindly, yes, my lord, kindly,
No, I want to
Yes.
know one thing from you. Plaintiff and parents were living
yes,
in the premises.
yes.
They were also living in the same premises.
Yes,
So let them both live together.
yes.
My lord, they are not living.
Order is not to disturb.
No,
The order is not that they will not enter the premises.
I have been dispossessed with my parents.
They will be restored.
Restored,
But if he is living, he can continue to live.
my lord,
My lord.
from the order of the trial, Miss Appeal Court, my lord, there is no finding that he is living there. No finding from the Miss Appeal. Only I have the impugned order from the net I have taken, my lord.
No, I have it with me. If
Yes,
it has
madam.
not, his possession has,
Yes,
possession has not been believed by either.
by the court.
My lord, the possession, my lord, I am in possession for 20 years. I have been stated in the written statement even.
Court says that the house came up 12 years ago. How could you have been in possession for 20 years?
My lord, this is the house of the father, my lord. We both are, my lord, son and daughters.
Challenge the injunction application order.
And that was not challenged in
Then
time,
there
my
is
lord.
categorical
was-
finding, disbelieving your possession, both by the trial court at the state of injunction, and by this court when this order was being assailed.
But my lord, the police report shows, my lord, I am in possession for 20 years.
No, police report said that at that time you were in possession.
My lord, at that point of time, my lord, at the time of filing of declaration suit, my lord, I was in possession. Even if, my
But
lord,
I think, in the order of the trial judge, he has found that you have a prima facie case and all that, but who was in possession has not been said, but the court believed that you are in possession.
My lord, kindly come to page 20, paragraph 21, page 10 of the impugned order. My lord, most of the documents are
I've seen
created
that.
by the obtain alleged dispossession of the plaintiff on a raised document bearing in address. So the document was not.
When was the order of injunction passed?
Order.
order of injunction passed in 2019.
No, your possession.
3rd of January.
is even in the temporary injunction application.
The initial stage status quo injunction was granted. Subsequent thereafter, my lord,
Not to disturb.
not to disturb the peaceful possession.
Thereafter dispossession.
But
No, but your possession in the trial court's order, in the temporary injunction order, the trial court has held. See in at the bottom, first page bottom, that he has shown the record of rights, the deed of gift.
yes,
You have not been able to show anything to
against
Substance,
this.
yes.
And the fact that you were in possession for 20 years is not true, because since the house only came up 12 years ago.
My lord, the deed of gift is in his favor by the
So-
father.
So
My lord, that is admitted.
take down. The revisional application is directed against an order passed by the learned district judge at Midnapur in Miss Appeal number 21 of 2023. By the said order, the learned lower appellate court upheld the order of mandatory injunction passed by the learned civil judge junior division third court at Midnapur in title suit number 34 of 2017. The petitioner is aggrieved because the learned court, lower appellate court failed to appreciate the possession of the petitioner in the suit property, and also the fact that an earlier order for restoration and application for restoration of possession was disposed of without any mandatory directions. Learned advocate submits that the said order would operate as res judicata. Next paragraph. The facts of the case in brief are that the plaintiff, opposite part plaintiff, one plaintiff only.
One plaintiff,
Sole,
sole
sole,
plaintiff.
sole plaintiff.
The plaintiff filed a suit for declaration and injunction and recovery of possession, and alternatively recovery of possession in the court of the learned civil judge junior division third court at Midnapur. Upon contested hearing, an application for temporary injunction was disposed of, restraining and or prohibiting the defendants oblique petitioners from interfering with the peaceful possession of the plaintiffs in respect of the suit plaintiff with respect to the suit property till the disposal of the suit. The defendants did not prefer any appeal from the said order. Neither did the defendants prefer any application under Order 39, Rule 4 of the Code of Civil Procedure for variation, vacation, or modification of the order of temporary injunction. On or about August 19, 2022, the defendants allegedly trespassed into the property and forcibly dispossessed the plaintiff along with his aged parents from the suit property. The plaintiff filed an application seeking restoration of possession. For the first time on
September 2020.
September 8, 2022. Thereafter, the plaintiff again filed another application for restoration of possession. Where is that? On
16 January 2006.
23.
January 16, 2022.
23.
23. In the said application, the plaintiff had categorically mentioned the factum of dispossession and the present and also that the plaintiff along with the aged parents were living in a makeshift arrangement
above a shop. The said above a roadside stall. ঠিক আছে? The father of the plaintiff was 70 years old and the mother, who was 65, was suffering from partial paralysis due to for having suffered a cerebral attack. That the makeshift arrangement was had a tarpaulin shade A police report had been called for by the learned court below. Learned trial judge. The defendants denied such allegations and submitted that they have been in possession of the property in question for the past 20 years. In support of such contentions, at the time of hearing of the application for mandatory injunction, defendants furnished certain documents in support of their possession. Next paragraph. Having heard the uncontested hearing, the learned trial judge allowed the application for restoration of possession with and directed the officer in charge, Debra Police Station, to assist the plaintiff in getting back possession. The learned trial court found that the learned trial court held that once there was an order of restraint and an order of police help. The order of restraint by way of a temporary injunction dated January 3, 2019, and an order of police help dated October 7, 2021, directing dated October 7, 2021. The parties who have, in respect of whom the order has been passed, must comply with the same in order to maintain the sanctity of the court, of the order of the court. If a party is allowed to surreptitiously is allowed to disobey an order, as was in the present case, the same would amount to abuse of process of court, and the civil court would be rendered powerless, even if no steps are taken to remedy the wrong which was committed in violation of the order of injunction. Considering the fact that the plaintiff had sufficient documents to show his possession, and further considering the fact that the aged parents who were seriously ill could not live in a tarpaulin shed house, the court directed that the atrocities of the defendant must stop, and otherwise the same would lead to serious considerations, miscarriage of justice, and would cause irreparable loss and injury to the plaintiffs and especially the aged parents. Next paragraph. Such order dated February 1, 2023 was challenged by the petitioners in Miss Appeal number 21 of 2023. Miss Appeal number 21 of 2023 came up for hearing before the learned district judge, Paschim Medinipur. the learned district judge, the learned lower appellate court framed the following issues. এই যে পেজ এখানটায় সার্টিফাইড কপি তো এই মুর্মু এটাকে একটুখানি শার্পেন করে দাও এখানে প্যারাগ্রাফ 5 the learned lower appellate court discussed the facts in details and arrived at the conclusion that
Paragraph 23 onwards, my lord.
that the learned trial court was justified in passing an order of mandatory injunction, thereby directing the defendants to restore possession, with a further direction upon the police authorities to aid the plaintiff in such process of restoration of possession. According to the learned lower appellate court, the points which weighed heavily in the mind of the lower in the process of the decision by the lower appellate court are as follows. A, Order 39, Rule 1 of the Code of Civil Procedure empowered the learned trial judge to grant an injunction and restrain a party from disturbing the peaceful possession, restrain the defendants from disturbing the peaceful possession of the plaintiff in the suit property. Next B, Section 94E of the Code of Civil Procedure empowered the court to pass interlocutory orders from time to time, which according to the court would be just, proper and convenient. C, there was no confusion, there was no prima facie confusion with regard to the fact that the defendants did not have any right, title, and interest in the property, whereas, the learned trial judge had found prima facie evidence of possession of the plaintiff on the base and title of the plaintiff on the basis of the deed of gift executed by the parents in favor of the plaintiff, as also the record of rights, which was which gave rise to a presumption of possession of the plaintiff. D, the fact that the parents were living with the plaintiff in the said house was not in dispute. E, the order of injunction was neither challenged by way of an appeal, nor did the defendants pray for variation, vacation, or modification of the said order. Was neither challenged by way of an appeal, nor was any application under Order 39, Rule 4 of the Code of Civil Procedure passed in for variation, vacation, or modification, vacation or modification of the said order. Tapore, on 18th August 2022, the plaintiff and the parents were dispossessed. The police and the police report supported such contention. That it was in consonance with with public policy that an order of injunction must be followed by the parties, or else the same would amount to miscarriage of justice and the courts would be rendered powerless. With regard to, next paragraph, with regard to the possession of the defendants in respect of the suit property, the learned lower appellate court observed as follows. A. The trade registration certificate dated February 11, 2023, comma, receipts of trade license fee dated September 2019, February 2021, July 5, 2021, did not show any address of, reflect the address of the suit property. Form number 2 of the Panchayat dated October 17, 2019, and the tax receipts did not have any description or address of the suit property. The meter reading card did not contain the address of the suit property. পরপর লিখে যাচ্ছেন তো A, B, তারপরে হচ্ছে the documents which were submitted by the defendant in proof of his possession were either created or obtained after the date of disposition. Most of the documents were bereft of any specific address of the suit property. The police report also indicated that the defendants had refused to comply with the order of the civil court despite attempts having been made by the police authorities. Next, documents filed by the plaintiffs indicated that the plaintiff had been gifted the property by the parents. The record of rights were in the name of the plaintiff, and the old and ailing parents were living with the plaintiff in a tarpaulin shed house next to the shop. On the basis of such factual findings, the learned lower appellate court upheld the order of the trial judge. With regard to the issue as to whether the early order passed in the earlier application for restoration would amount to constructive res judicata, the learned lower appellate court found that the prayers were different and the said application was not disposed of on merits. Next. Referring to a decision of the Honorable Apex Court, the learned lower appellate court held that it was within the jurisdiction of the learned child judge to pass an order under section 151 of the Code of Civil Procedure, thereby restoring possession to the plaintiff and the parents who were already in possession, who were found to be prima facie in possession at the time of disposal of the temporary injunction application. Referring to a decision of the Honorable Apex Court in Tanushree Basu and others versus Ishani Prasad Basu and others, reported in AIR 2008 Supreme Court 1909, the learned trial judge, the learned lower appellate court held that the law would not permit a party to a suit to take a party to a suit could not take the law in his own hands during the pendency of the suit and thereby disposes a co-sharer or any other person in possession. If such situation occurs, either in violation of an order of injunction or otherwise, the court indisputably would have the jurisdiction to restore the parties back to the same position. In the matter of Manoj Kumar Maji and others, and Suman Maji and another, reported in 2019 within bracket 1 within ICC, it's pages 6 and 7 of the yete page, appeal court's decision. It was held that the court had every authority to invoke its inherent jurisdiction for protection of the rights of individuals and parties to the suit. Next, referring to the decision in Shujit Pal versus Prabir Kumar Sen and others, reported in AIR 1986, Calcutta 2020, the learned lower appellate court observed that the inherent power of the court to restore possession to a party wronged during the pendency of the suit by another party was in addition to the provisions of Order 39, Rule 2A of the Code of Civil Procedure. Next paragraph. The scope of a revisional court is very limited. The revisional court can only interfere when a judgment is perverse. The judgment is an order is perverse or based or suffers from material irregularity. Next paragraph. According to the court, an order can be treated to be perverse on the following grounds. A, if order has been passed contrary to the evidence. B, if an order has been passed contrary to law. C, if an order has been passed without considering the material facts. Next paragraph. In this case, the learned lower appellate court entered into the factual aspect as also discussed the law. The learned lower appellate court has found that factually found that the police report supported the cause, this version of the plaintiff. That the police report indicated that the plaintiff was living with his aged and ailing parents in a tarpaulin shade makeshift house above near the shop. That the order of injunction clearly stated restrained the defendants from interfering with the peaceful possession of the plaintiff in respect of the pursued property. That the defendants did not take recourse to the remedies under the law challenging such order of injunction. The factum of dispossession was also mentioned in the police report. That the earlier application which was moved was disposed of without any hearing on merits, and as such the principles of res judicata would not be applicable. Finally, numerous case laws were discussed in order to substantiate the point that the learned trial judge had the inherent power, had rightly invoked the inherent power under section 151 of the Code of Civil Procedure to do substantial justice by restoring possession to the petitioner and the parents, failing which it would amount to not only miscarriage of justice, but the sanctity of an order of a court would be completely negated and destroyed. আচ্ছা ওইখানে factual part গুলো that করে বললাম না, ওখানে আরেকটা লেখো, that the documents which were produced by each and every document produced by the defendant to support his contention of possession was categorically examined and found that none of them related to the suit property, and most of them were created after, no, were dated after the factum of dispossession. The question of dispossession was never, no, there was no evidence forthcoming from the defendants that the plaintiff and the parents had not been made to live forcefully, no, had not been dispossessed, and they were not living in that tarpaulin shed house as confirmed by the police report. Under such circumstances, the revisional court cannot interfere with the above findings. The revision is dismissed.
Grateful.
Next. Passover to আসেন এসছে? You've come. Just when I have a Passover, one Passover.
Well, the petitioner, my lord, as the order of the learned appellate court, refusing to
145.
pass an administrative order of injunction.
Hmm.
Only on the ground that they are insufficient of documents.
Who passed?
My lord, the learned district judge at South 24 was Adlipur.
Trial judge?
Trial judge on the ground of urgency and no sufficient documents. My lord, whatever the documents I have, I'm in my custody, I have, my lord, annexed with the injunction application. My lord, the lordship kindly have a look to the impugned order first, my lord. My lord, at page 61, my lord, the learned trial court, my lord, refused the administrative order of injunction on the grounds of urgency
Where
and
is the trial court's order?
my lord, trial court's order that no
Where is that?
page 61.
61.
Yes, my lord. আপনি বলছেন
Yes, appeal has to be heard.
No, my lord, kindly appreciate, my lord. My lord, kindly appreciate.
Settled law.
My lord. My lord,
It is
kindly.
well settled that order refusal of an ad interim order, all that the High Court can do is direct the lower appellate court to decide the appeal.
Right.
I'll fix it.
My lord, in the meantime, my lord, kindly appreciate. My lord, kindly appreciate one thing. My lord,
This is not a writ petition. There is
My-
not much scope
no,
for
no, my lord, I am not. My lord, kindly, my lord, appreciate the factual aspect. My lord, my lord,
Factual aspect is well appreciated. You have yourself executed the lease and now you want to retract from that. Court is right in saying that unless I hear the defendants, how can I retract?
my lord, it is hid by section 16 of the Indian Contract Act, my lord.
Maybe
Because of the fact, my
that
lord.
is your suit.
My lord,
That is not injunction. Take down.
now, my lord, kindly appreciate. My lord, every right he has accrued.
Yes.
Lordship,
this is
kindly hear me for a moment. Lordship,
an
kindly hear me.
application for
Kindly
challenging.
hear me, my lord. Otherwise,
Hearing all those days are
multiplicity
gone.
proceeding will take place. My lord, if the
What multiplicity?
because sublet power of sublet is there. My lord, they are making construction.
So it is not in dispute that you have yourself entered into a lease with someone.
That was, my lord, by
So that
misrepresentation.
misrepresentation and mistake has to be prima facie been satisfied. They will do it.
But in the meantime, status quo by both the parties. My lord, I also not to do anything with regard to the, my
I
lord.
will direct the appeal court to expedite the
Yes,
hearing
my
of
lord,
the
in the meantime, status quo by both the parties.
No.
Status quo by both the parties, because I also do not want to, my lord, take any steps with regard to the suit property. But my
What
lord,
step can you take? You are not in possession only.
my lord, I can sell it out, my lord.
Wow.
I can transfer, my lord, because
No.
my lord,
nothing.
factual aspect, my lord, they have power of sublet is there. Lordship kindly appreciate, my lord, that if any third party interest is created in the meantime, my lord, multiplicity of
I will
process.
direct that the appeal, you have filed an application for injunction.
That has been refused.
Yes, the ad interim stage has been refused.
Yes, injunction.
It is expedited.
But in the meantime, Lordship
3
kindly
months, nothing
appreciate.
will happen.
Status quo by
How
both the
long was
parties.
it pending before this court? Oh no, this is new filing.
New filing, my lord.
ঠিক আছে. The
Well,
revisional application has
Status
been
quo might
rejected
be by both the parties, my lord. Because
against an order
nobody would be
dated
prejudiced.
April 11, 2023. ওই জাজমেন্টে দেন না পার্থ যে ad interim রিফিউজ করলে অ্যাপেলেট কোর্ট দ্য রেমিড দেন না কি বললাম passed by the learned district judge South 24 Parganas at Alipur refusing to grant an ad interim stay. Refusing to grant any ad interim order of injunction against the defendants without defendants on the ground that in the absence of sufficient documents and in the absence of a prima facie case, interim order of injunction could not be passed. The plaintiff filed a suit for the petitioners as plaintiffs filed a suit for declaration, injunction and recovery of khas possession and damages against the opposite party in the court of the learned
Seventh civil. Seventh civil judge senior division.
Civil Judge Senior Division 7 Court and Alipur. The plaintiff petitioners prayed for an ad interim injunction. The ad interim injunction was refused by the learned trial court on the following grounds. A, no original documents had been filed of the gift deed or the lease deed. B, the Although there was a restriction of transfer and alienation of the property for a period of 10 years, the plaintiffs themselves had entered into a lease agreement with the opposite party and had transferred and had granted 99 years lease in favor of the defendant. C. Between 1996 to 2021, now the seat of the due to misrepresentation, the factum of misrepresentation by the defendants, which led to the execution of the lease deed for 99 years, would not be established unless sufficient documents were produced, either sufficient documents were produced or the defendants were heard. When the defendant started raising a house, prepared to start a construction, the plaintiffs suddenly became aware of the embargo in execution of the said lease deed, although they were all parties to the same.
Along with the deceased mother.
Along with the deceased mother. আগে ওই যেখানে ট্রান্সফার করছে along with the deceased mother করবে। Thus, the learned court below, or the learned trial judge, was of the view that the plaintiffs did not prove any urgency. তারপরে হচ্ছে the facts revealed that the defendants were in possession of the suit property since long. In view of the lack of urgency in the matter, the prayer for injunction was refused. Ad interim injunction. Next paragraph. This court finds that the plaintiffs had been gifted with the property sometime in 1991. Although in the gift deed it was covenanted, C-O-V-E-N-A-N-T-E-D, that the donee, that is the predecessor, the predecessor in interest of the plaintiffs, were gifted the property by the government of West Bengal in the year 1991. The plaintiffs are now enjoying the claim right title in interest through their predecessor in interest. The predecessor in interest of the plaintiffs did not have any right to alienate or transfer the property in any manner whatsoever within the period of 10 years from the date of execution of the said deed of gift. Thereafter, the plaintiffs thereafter the plaintiffs entered into the lease agreement with the opposite party and registered the deed of lease. When was this lease deed
Well,
executed?
2nd day of September 96. 5 years.
5 years after their predecessor in interest had come in possession of the said property. When the plaintiff wanted to transfer the suit property to a third party, the defendants raised objection. Even if the plaintiff realized the mistake in even assuming that the plaintiffs were misled into executing the lease deed, they kept quiet from 1996 to 2021. Thus, the court does not find any reason to interfere with the orders impugned, as the courts have rightly held that the learned trial judge rightly held that there was no immediate urgency to grant a ad interim order of injunction restraining the defendants from using the suit property in any manner whatsoever.
Not using, my lord.
For
Creating any third party interest.
what was your nature of injunction prayed?
My lord, kindly I will look, my lord, the prayer of the my lord plaint. That is at my lord page 56.
No, what is the injunction application?
The injunction application, injunction prayed, my lord.
Order of injunction restraining the defendants from using the suit property in any manner without giving an opportunity of hearing to the said defendants who were admittedly in settled possession of the suit property. Possession of the suit property. Whether the petitioners are entitled to an ad interim order of status quo or not shall be decided in the appeal, which is pending before the learned district judge, South 24 Parganas at Alipur, by Miss Appeal number 46 of 2023. This court is of the opinion that justice would be subserved if expeditious steps are taken for what is the next date? Disposal of the Miss Appeal along and
My lord, 11th May was the last date. Thereafter, my lord, 11th May was
for disposal of the application for stay as also the Miss Appeal within a period of 4 months from the next date fixed.
take it 2 months.
Service,
Service, my lord, within Kolkata. My lord.
you have to serve.
I will serve, my lord, within the Kolkata jurisdiction, my lord. 2 months, my lord, kindly, because I have got urgent.
You have got
Urgency in the matter.
no urgency.
Well, if any third party interest is created in the meantime, that will be the difficult.
And then
Well, only my lord status quo. I am not, my lord.
Judgment দাও একটু দিয়ে দিতে হবে in the decision in ওইটা দিয়ে দেবে in so and so the honorable this honorable court has held that this is by whom?
My lord, Justice,
Shubha Kamal Mukherjee followed it.
subsequent judgments are there. Shubha Mukherjee, drafted by Justice Standard.
Yes. ওটা একটু দিয়ে দাও
Answer landing. Justice Standard. Rarest of rare cases, such stay can be granted, but
হ্যাঁ কি বললাম? Which have been subsequently followed by the decisions in so and so. It is said the law has been followed in the decisions of dash dash. The law is well settled that except under very, very rare circumstances, exceptional circumstances, except in exceptional circumstances, the revisional court should not pass. No, the proper course would be, the proper course for the revisional court would be to direct the main misappeal to be heard out. Direct the main misappeal to be heard out. Yes. Next. Raho.
I am for the petitioner, my dear.
Yes. ওটা না অর্ডার শিটের উপরে স্টেপল করে দেবেন তো। Yes.
The defendant here filed this revision application before your lordship. The plaintiff filed an ejectment suit before the learned court below for eviction of the defendant. Now, no notice of summons was served. Thereafter, on 3/8/2022, on the basis of an application filed by the defendant, he entered appearance. Subsequently, on 2/9/2022, he filed an application under Section 7(1) of the PT Act for payment of arrear rent and the current rent. That was allowed by the learned court below. That amount could not be deposited due to the fact that his only nephew was suffering from cancer. He was away from Calcutta to Mumbai upon collecting some money because he is a carpenter by profession. He could not collect the money. Therefore, that amount could not be deposited. Thereafter, an application was filed before the learned court below for extension of time to extend the time for deposit the said rent. That was rejected by the learned court below. On the basis of impugner, I come before
Yes,
you.
but isn't that the law now that you section delay cannot be condoned?
But I have a judgment of this honorable court division bench. Here, your lordship kindly please.
7-2 says one chance.
What?
What does
One
7-2 say?
chance may be given.
এটা বোধহয় 7-2 তে আছে, দেখো তো 7-2 টা premises tenancy একটা একটু দাও।
Last, the bottom portion of your lordship here, this honorable court passed in judgment in this matter, granting
Which paragraph?
last paragraph, page 12, last paragraph. The time limit as mentioned in
No, by virtue of section 5, now Supreme Court has said not applicable. This is of 2000 which year?
Is it 2010?
Judgment দেন না Supreme Court. Justice Shiv Khan Prasad passed an order over here, and then that view was upheld. কি করা যাবে এখন? কিছু করার নেই।
But the section itself says time may be extended. Your lordship kindly see section 7, my lord. Sections 7, my lord, regard to the circumstances proviso, an extension of time may be granted by civil lawyer only once, and the period.
One extension can be given.
One extension can be granted. I am paying for such extension only, so that the amount can be deposited. Shall not exceed 2 months.
Where is that?
Premises tenancy act.
No, which section are you talking about?
Section 7.
7-1.
7 to Proviso to subsection 2. পুরনো যায়নি গর্জি দিয়েছিল শিবকান্ত প্রসাদ না কি যেন
But this was a determination not under 7.2,
not 7.2.
very 7.1 ordered, order under 7.1.
Your lordship kindly last portion, the ordering page, it is not marked. Page 1. Page 4. Page 4, page 5. Ordering portion page, last page. তোমাদের না কিছু না মমতা করা যায় সমস্ত আমার কি টাকা জমা দেবে না কিছু না অর্ডার করে দিলাম 500 টাকা 500 টাকা 1000 টাকা করে দিলাম আমি আর কি করবো চলো যা হবে আর করার কি আছে
Yes, Vijay Kumar Singh and what Chamaria. It's there.
Vijay Kumar Singh.
You did not file anything under 7.2, so how will that proviso help you?
No, I have not filed.
Then,
I have not filed. I have filed 7 months ago.
Ovena, Gallo, defense. Chalo,
Your lordship.
কিছু করার নেই। অনেকের প্রবলেম হয় কি
My lord, problem, my lord.
I have argued for matter.
Hmm.
45 was not considered. 45 is the statute itself says that restriction is inbuilt. If the such a limitation act will apply.
Unless there's a review of the Supreme Court order, what will we do?
Your lordship has that you can translate your lordship manner. Once in that manner, 5 was.
By whom? Okay.
I'll submit the judgment to your lordship.
Take down. The petitioner has alleged, has impugned the order dated April 4, 2023, passed by the learned Chief Judge, Presidency, Small Causes Court, Calcutta, in ejectment suit number 233 of 2021. The learned judge was of the view that in view of, by applying the judgment of the Honorable Apex Court in the matter of Bijoy Kumar Singh and others versus Amit Kumar Chamaria, reported in 2020, within bracket 1 Indian Civil Cases 664, the tenant cannot be allowed to deposit the area rent beyond a period of 1 month as per the order beyond the period specified by the statute. Under section 7(1) of the West Bengal Premises Tenancy Act. Section 7(1) of the West Bengal Premises Tenancy Act is quoted below. এখানে কোট করা আছে, আপনি বই এটাও নিয়ে নিতে পারেন। এখানে করে দিয়েছি। In Bijoy Kumar Singh and others versus Amit Kumar Chamaria, the Honorable Apex Court held that if a tenant fails to deposit admitted area rent within 1 month from receipt of summons or within 1 month of appearance without summons, and also fails to make an application for determination of the disputed amount of rate of rent and the period of arrears, for determination of disputed amount of rate of rent বলেছি, and the period of arrears, and the subsequent non-payment on determining the arrears of rent will entail the eviction of the tenant under section 7 of the Act. Now, eviction of the tenant, full stop. Section 7 of the West Bengal Premises Tenancy Act, 1997, provides a complete mechanism for avoiding eviction on the ground of non-payment of arrears, on the ground of arrears of rent, provided that the tenant takes steps as contemplated under subsection 2 of section 7 of the Act and deposits the arrears of rent on determination of the disputed amount. The deposit of rent is a precondition to avoid eviction on the ground of non-payment of arrear of rent. This was a suit for eviction on the ground of default.
Default. And reasonable requirement.
The language of the section has been strictly interpreted both by this court and has been strictly interpreted of section 7(1) has been strictly interpreted both by this honorable court in some recent decisions and by the Honorable Apex Court. The Honorable Apex Court has categorically held that the section 7(1) of the Act does not leave any room or scope for a court to condone the delay in payment of the arrear rent contrary to the time limit fixed by the statute by application of section 5 of the Limitation Act. The decision submitted by Mr. Nirmalo title ki?
Thus,
Mr. Das of a division bench of this court in CO 3443 of 2010 read with CO 3054 of 2011 would no longer be applicable in view of the decision rendered by the Honorable Apex Court. Under such circumstances, the trial court has not erred in rejecting the application for deposit of belated rent upon condonation of delay, belated area rent upon condonation of delay more than, when was the order in 7-1 passed?
39, 29, 39,
22.
22.
And the application after more than 4 months from the order, from the date of the order under section 7, disposal, from the date of disposal of the application under section 7(1) of the West Bengal Premises Tenancy Act. Ninth to 11, 12, 9 September. The revisional application is hence dismissed.
I'm good.
এই যে না এই ওটা ওকে মন্ডলের লাগবে এটা ওকে দিয়া ফাইলের সঙ্গে দিয়ে yes next
My lord, I am led by Mr. Pradeep Mukherjee. I am praying for short pass over.
115
13, my lord, I am appearing for the petitioner.
hmm
My lord, plaintiff degree holder is the petitioner of your lordship. In a suit for declaration of title permanent injunction, the suit was decreed. Subsequently, the petitioner was disposed and the degree put into execution in terms of section 32 of the Civil Code of Civil Procedure. Permanent degree of injunction can be put into execution. Against that, an appeal was filed by the defendant. In such an appeal, my lord, an application for stay of the operation of the judgment or degree was spread for. Now, my lord, can you consider the order impugned, whereby it was granted stay cannot be granted regarding the operation of judgment and decree.
from putting the decree into execution it can be granted.
Execution to be said. If that be said, then my lord, I have right to pray for
Occupation
occupation. You cannot claim occupation as such, but some security for obtaining stay. Now, my lord, can you turn to the order passed by the learned court of appeal below? Page 20, that is the order dated 28 February 2023. Extension, I said, I filed to objection.
decree for permanent injunction, if you get a decree for permanent injunction, you can't execute that decree.
Yes.
How? You have to file a suit.
No, my lord. Permanent
How
injunction.
is that decree executable?
Yes, if my lord, I have to show that the degree has, after passing of the degree, I have been disposed of.
Yes, after the passing, you
Yes.
have to be disposed.
Then, my lord, I can file an application under section 32 for execution of the permanent degree, and it will be degree will be executed in terms of section order 21 rule 32, not 35. 35 is just the immovable property where the khas position has been declared. 32 is the injunction and the specific permanence of contract, where, my lord, this sort of degree can be executed. Stay of the operation of the judgment and degree practically allowing the appeal at the interlocutory stage. What the principle which allowed by my lord at the time of rejecting that application, the stay granted by at the interlocutory stage amounts to allowing the appeal at the interlocutory stage. Same thing applies there also. He can file he can grant injunction restraining me from proceeding the execution case or something to that, or injunction protecting his position. But stay cannot be granted. That too without
All
giving.
right, service. Upon the
Opposite party, defendants opposite.
opposite party defendants, as also the learned advocate conducting their case in the learned lower appellate court, stay of all further proceedings entitled appeal number 18 of 2022 for a period of up to August 31, 2023. Let this matter appear as a new motion on
As your lordship please.
22 তারিখ দিয়ে দিন না 22 অনেকগুলো আছে বোধহয় না 28.
As your lordship. And my lord was pleased to observe in the earlier matter, my lord, the Supreme Court in the judgment of there has been Indri Vijay Kumar Singh and others versus Amit Kumar Chameria.
Kumar Chamaria.
Amit Kumar Chameria.
তো অমিত কুমার বলিনি, অমিত বলেছি তো,
Indri Vijay Kumar Singh versus Indri Amit Kumar Chameria passed by this.
কুমার সিংই বলেছি বোধহয়, দেখো তো,
প্রথমে বলেছে
সিং ভার্সেস অমিত কুমার
Yes,
চুমার।
yes.
হ্যাঁ। ঠিক আছে, 28 তারিখে দিয়ে দিন নিউ মোশন, 28 জুন।
July, as your lordship please, July.
31.
Careful.
So these are small matters, so I want to finish them off.
With it granted to consider the application for stay in my presence.
Huh?
Consider the application for stay in my presence because I want to file objection, could dispose of the orders.
Stay has been disposed of
Yes.
in your absence.
I want to file an objection. Stay.
ওখানে prima facie it appears that the defendant ought to have been given an opportunity, the
Plaintiff respondent.
degree holder ought to have been given an opportunity to file an objection to the application for stay instead of to the application for stay filed in the misappeal, in the
Title
regular
appeal.
title appeal, before the said application could be disposed of by granting a stay of the decree, operation of the judgment and decree, which prima facie appears to be, which also prima facie appears to be allowing the main relief in the appeal. No, but ওটা তা নয় কিন্তু।
Yes.
How? This is not an appeal against an interim.
Yes. No, my lord, if the judgment and degree which has passed,
Main relief in the appeal.
main relief is granted.
But in a suit, what security can you ask for in this suit? If it is
Yes.
eviction suit,
No.
information, one thing.
Money. The Supreme Court says the irrespective of fact, if you want to stall any execution proceedings, then you have to seek.
Judgment
Yes,
on the next day.
yes. In a partisan suit also, my lord.
Yes, that I have also in a TP Act also I have given.
Yes, this sort of you have dispossessed. If ultimately found I have been
I
dispossessed,
don't know whether Supreme Court interfered with my order, but I have given in a
so
case.
if it is
Trespasser.
yes, the Supreme Court has said in that way that if subsequently found that yes, I have been dispossessed or thrown out illegally, then I have been deprived from using my property. Yes, a degree has been passed, so I have to my interest should be protected.
Pray over there.
Yes, yes.
But
No,
still-
not here. I have to pray over there.
Yes, all right, but you bring that judgment.
Yes.
Yes. Next.
Yes, madam. I am for the petitioner decree holder, madam. Early disposal of the execution proceeding, madam. I have been suffering since 2011. There was an agreement between the decree holder.
No, I am asking you, is there any application pending in the execution proceeding?
Matter was, this is the arbitration award, and arbitration award was passed ex parte. Thereafter, I have filed one execution case before the learned district judge at Barasat in the year 2019, my lord. Learned district judge has subsequently transferred the said case before the learned first civil judge, senior division at Barasat in the year 2019. Now 2023, after lapse of 4 years, there is no progress of the case, my lord. That's why I am coming here.
They have not filed, challenged the,
No, madam, no appeal has yet been filed by the.
take down. The petitioner prays for expeditious disposal of arbitration execution case number 334 of 2019. It has been renumbered,
Yes, madam.
which has since been renumbered as arbitration execution case number 13 of 2020, comma, now pending before the learned civil judge, senior division, first court at Barasat,
Barasat.
district 24 Parganas South.
Not.
Or not?
Not.
As this is an innocuous prayer, this court is of the view that the execution case must be expedited and disposed of. the expedition of the execution case cannot cause any injustice to any of the parties. Hence, no notice of hence no further notice is required to be served upon the opposite parties. The revisional application is thus disposed of with the direction upon the learned court below to conclude the execution case arbitration execution case number 13 of 2020 within a period of 6 months from date of communication of this order, strictly in accordance with law and without granting any unnecessary adjournments to the parties. Such order will be subject to any other order that may be filed by a competent court of law. It is also it is submitted that no appeal from the said award had been preferred by the opposite parties. ঠিক আছে, তারপর নিচে চলে যাও। Yes, it is made clear that this court has not gone into the merits of the award, has neither gone into the merits of the award nor into the merits of the execution case. This order shall not be concluded as a decision or an opinion of this court on the sustainability and the a court on the allegations or contentions of the petitioners, or an opinion of the court on the right, title, and interest of the right and interest of the decree holder, right, interest, and validity of the claim of the decree holder in the execution proceedings. Award holder. ঠিক আছে? A copy of this application be served upon the opposite party along with a server copy of this order within a week. You will serve this copy upon the opposite parties.
Yes.
Disposed of, but you will serve them.
Yes, ma'am. I communicate this order.
And not only the order, copy of the order and the copy of this revisional
Please use
application.
that also. Hello.
Next.
For the petition in this matter, my lord, there is a suit for my lord, dissolution of marriage by the husband, who is a BDO of a my lord block. Now, my lord, in the suit
So 5,000 already paid.
5,000 and 4,500,
9,500.
my lord.
And you are earning 11,000.
11,000 contractual basis, page 68, my
Yes,
lord.
so if there is a problem with the job, then you can always pay for enhanced on changed circumstances. But this is all right.
My lord, your lordship, my lord, knows, my lord, 1/3 from the salary. Now this is a standard, my lord.
But she is working.
This is working in contractual basis.
1/3 from salary, 1/3 to 1/5.
1/3 to 1/5.
Yes.
Now, my lord, as per the standard of, my lord, the BDO, I'm the wife of the BDO.
But
So, my lord, now, my lord,
but she is working.
she's working, my lord, 11,000.
Who's not working may be given that formula. But she has a contractual job with the government.
My lord, may I sub copy and then come back, my lord? So
No,
that,
no.
my lord, here, my lord,
I will give you liberty because it is a contractual appointment. If situation is reversed, at any time you can pray for enhancement.
my lord, here, my lord,
When she is working and earning money,
my lord, 11,000 and my lord, the 9,500.
so now almost
So,
20,000.
almost 20,000. And my lord, if I consider, my lord, if I consider 1 lakh and 30, 1/3, then also 30,000. Some amount, my lord, kindly. Though there is no state jacket, but still, my lord, a BDO, my lord, he is enjoying his status, everything. I will driven out from home and he will file the case in, I have to, my lord, face the court cases. And this is the third litigations I am coming before this honorable court. You know, all these things are, my lord, your lordship knows. We are also
What is the salary of the BDO?
not less than 1 lakh per month. Your lordship knows, my lord, he's a highly graduated rank and senior BDO.
How much extension will happen?
5,000 to 10,000 at least, my lord, because it will not hamper his, my lord, anything, my lord. This kind of poor lady,
What is her? Show me her affidavit of asset.
affidavit of asset,
Hers, not his.
her.
She has 3 houses and 3 cars.
No, that is so.
Look at page 39. This is your own declaration.
No. Kindly see, my lord, the.
No, what? No. This is there.
No. Page 50. Kindly see.
No, please see page 39 first. Own accommodation, 3 houses, 3 cars, landed properties in different places. No, take down.
My lord, kindly, my lord, because.
See, everything has to be taken as a whole. Her standard is already maintained by her own self or through her.
My lord, may I check up this document, my lord? My lord, kindly, my lord, allow me.
Which is your own affidavit.
Page
39. The court has considered that.
Page 39, my lord.
We go beyond that.
So this is his, my lord, father's house, my lord.
Look at what she has written and what she has given in court.
My lord, this is the, my lord, then, my lord, may I come back? Because this is a father's house.
I cannot change that. This is a document filed in court. It's an affidavit of assets filed in the proceedings.
May I, my lord, ask, my lord, come back? Whether this.
Come back with any clarification.
No, because 3 houses, my lord, what is the houses? Is it whether mud house or, my lord, is.
It is not, it cannot be mud house. Nobody will have 3 mud houses. No, take down.
Well, may I come back with service, my lord, because.
No.
Kindly that, my lord, part, my lord, I am not asking.
We give you opportunity to pray for enhancement if circumstances change and your contractual appointment is not renewed. All right, take down.
My lord, 30%, my lord, at least, my lord, 1 lakh some amount may kindly, my lord, some, my lord, something, my lord, because I, my lord, facing, my lord, my lord, several litigations from Barasat to, my lord, this court, and, my lord, everywhere, my lord. And, my lord, the other, my lord, issues are also here, my lord, the medical issues are here, my lord. I have annexed the document, my lord. Some amount may kindly be, my lord, enhanced, or, my lord, lordships may give the liberty without any objection, so that I can pray, my lord, enhancement, my lord, in this position.
Time under change circumstance.
Change circumstances, my lord, in these circumstances, my lord, kindly,
Cannot.
at least some amount may kindly, my lord, enhance, my lord.
Per month, puja relief and ex gratia rupees so and so income from other sources not less than 30,000 per month. Look at your own affidavit.
My lord, I will then come back with instruction.
Not back with instruction because she's bound by this affidavit which she filed in court.
No, this is affidavit of her, my lord, of his husband.
Husband,
Yes. Yes. Yes, kindly see page 32,
oh Shubhra Singh Goswami has.
page 50, my lord, page 50.
Yes, take the service. Service upon the opposite party. Let the
Well-
matter appear on. Kotaka thake husband. Arterial Road, New Town.
My lord,
As also upon the learned advocate on record for the opposite party contesting the case, court matter in the learned court below. Let this matter appear on 28 June.
same heading. Same heading, my lord.
New motion. Huh?
Well.
No point in staying the suit.
No, not necessary.
Now, next.
I beg to appear for the petitioner in this matter. My lord, in a suit for eviction, the plaintiff, my lord, is seeking to, my lord, not, my lord, induct the legal heirs of the deceased defendant as parties in the suit, in a suit for eviction. My lord, he filed an application for exemption from bringing on record the legal heirs of the deceased defendant, which has been allowed. This is the sum and substance. Now, if your lordship kindly comes to the impugned order, my lord, the only ground is that the deceased defendant never participated in the proceedings. He did not file his. My lord, the impugned order, my lord, a certified copy, it is unnumbered.
What is the application for?
The application was filed by the plaintiff to this eviction suit. I am for the defendant. I am for one of the defendants who has come up before lordship as petitioners. My lord, the application was under order 20, my lord, order 23, rule 4, my lord, for exemption from bringing on record from substituting the legal heirs of the deceased defendant. If your lordship kindly comes to.
Did not want to bring them on record.
The plaintiff did not. I am for the other set of defendants. This is a joint tenancy. Everyone has common rights. Everyone has equal joint rights over every square inch of the property. Now, my lord, I'm for the other set of defendants. The one of the set of defendants, one defendant has died. His legal heirs are there very much. The plaintiff is desirous of not bringing them on record, and my lord, getting a decree against me, and for my lord, an ex parte decree against them. My lord, the suit was running ex parte. The suit was running ex parte for the defendant while being alive. The plaintiff claims while being alive, he failed to file his written statement and hence does not require to be substituted. But there is a provision he's relying on. If I may be allowed to place the provision. But if your lordship kindly comes to my lord. Lord, if your lordship kindly comes to 22 rule 4.
Yes, so
My lord, the defendant number 3's legal heirs, your lordship has gone through the my lord impugned order. The defendant number 3's legal heirs, if they are not my lord substituted, they will be completely non-suited.
what is your problem? They are not bothered.
I am a defendant in the suit. My lord, I am a joint defendant. I am a joint
If you
tenant.
delay, they will come, they will
The
file.
suit has,
against
yes,
it,
there, my lord, I have a,
go on forever.
there, my lord, there, my lord, I may submit this. But there, my lord, I may submit this. The suit is going on. So the evidence has commenced. There is no question of delay. There is no intention of delay. There has been no,
Yes.
my lord, I have. They have.
You, the substituted heirs, you're setting them up. They let them come and say, I want to contest now in presence of my father. They can.
My
come
lord,
and say,
my contention is, my lord, from the, if the lower court records are called for, my lord, it will be shown from there that the service was not, the summons were not properly served.
Nothing.
Lord, your
The court
lordship
has found on facts that summons were properly served. When was the suit filed?
2021, 2023 eviction suit, my lord, in cross-examination now.
When did the person die?
The person died in 2021. He was dead, my lord, either before or after the filing of the suit. My lord, immediately thereafter, or my lord, in the same my lord, time frame. My lord, the summons was served upon the dead person, which ultimately came back.
You add them as parties?
My lord, my application, if you, my lord, there I had made an attempt. Yes, I have made an attempt which has been by this common order dismissed. If you by this common order, that has been dismissed. If your lordship kindly comes to my application first, my lord, kindly takes a page 34. I'm sorry, my lord. Kindly takes a page 32. My lord, not happily drafted, not happily, my lord, titled, but this is an application for death reference of defendant number 3. I bring on record the fact of the death of the defendant number 3. I bring on record the names of the legal heirs. This is my lord, attempt, at the very least, an attempt to bring on record the legal heirs. By the common order, this has also been dismissed.
No, but if they are not interested, what is your problem?
My lord, ultimately, my lord, the suit will go on against the other defendants.
So let them
Although he
support.
has been my lord, implicated as parties, my lord,
If you're living in the same house, they are aware.
my lord, we are joint tenants.
So
Not,
if they they don't want to contest the suit.
my lord, they want to.
Huh?
May I, my lord, my lord, may I submit this, my lord? But in any case, my lord, this order, if your lordship kindly considers this, my lord, I completely follow, I completely bow down. Your lordship kindly consider this, my lord, this order, my lord, the court cannot, my lord, my lord, summarily reject this application, summarily allow this application, and my lord, completely non-suit the legal heirs of the defendant who has been made a party.
That argument is available to them.
My lord, in any case, this is a question of law. My humble submission, my lord, this is a question of law. This is a question of law, my lord.
The court does not, the revisional application is at the instance of the defendants in a suit for rejectment. The suit is at the stage of cross-examination. The defendant number 3 died during the pendency of the suit. The plaintiff filed an application under Order 22, Rule 4 of the Code of Civil Procedure. For exemption from substituting the heirs of the deceased defendant number 3. No, you can tell him what you want. This is fair. No, you can. Tell him. This can happen. কি বললেন? From substituting the heirs of the
So very grateful, my lord, to my
number
lord, Mr. Chatterjee and your lordship, my lord. But this will ultimately turn up as a suit against a dead man. Because my lord, the summons has been served on a dead man.
Yes, so it will not be a suit against the dead man. It will abate against the defendant, heirs of the defendant number 3. Against them, not
Against the other defendants. And if your lordship also kindly records, my lord, this question of joint tenancy.
Yes, Mr. Chatterjee. That's a problem. But then I don't think it's joint.
That, my lord, I shall.
They have each individual shares.
My lord, they are coming from the common predecessor. Coming from the common predecessor. The interest has come down from the common predecessor.
In the sense like
The father, yes, may I? From the plaintiff itself, if I may.
From the plaintiff. Who are they are brothers? The defendants?
Brothers from the same predecessor interest. If your lordship kindly comes to, my lord, may I place, my lord? The plaint starts at page 14. My lord, I'll have to place from paragraph 3 onwards, which starts at page 15.
Who was the original tenant? Gita?
My lord, no, my lord, Bhavanath Banerjee, the predecessor in interest, Geetika Banerjee was, my lord, the wife, the widow of Bhavanath Banerjee. I am, my lord, the আমি তো grandchildren. We are, my lord, the grandchildren of Bhavanath Banerjee, the original tenant.
আমি তো এমনি 2G তে কিছু
No, thereafter, if your lordship kindly reads on. No.
no.
It is not that. If your lordship kindly reads on, kindly comes to. No, 2G is not applying.
Banerjee,
Yes.
the daughters were substitute.
Your lordship kindly reads on. Your lordship kindly reads on. My lord, kindly comes to the next page. My lord, thereafter, rent receipt was changed. The tenancy was, my lord, changed. Tenancy was changed in the name of Geeta Banerjee and others. No one knows who these others constitute. Geeta Banerjee and others. That is a question of, my lord, evidence. Who these others constitute. Kindly comes to page 16, my lord. This is only the second line.
This is
My predecessor is, my lord,
defendant number 3.
different number 3 and I have common predecessors. Different number 3 and I have common predecessors as Geeta Banerjee. Now, my lord, this tenancy is in the name of Geeta Banerjee and others.
Why will it be? If the eviction suit fails, it fails.
No,
And if it is successful, you have to leave.
no, sir, the rights of the other legal heirs to get themselves inducted in the suit. But this order might not, my lord, affect their rights.
Those who are contesting are contesting. I've said that they have their remedy.
Deeply obliged, my lord.
Convince them to participate if you want to delay.
Deeply obliged, my lord.
Anyway, grandchildren have nothing under the law. Huh? When 12, order 12, sub-rule, rule 4, sub-rule 4.
Order 22, sir.
Order 22, sorry. Yes, yes, yes.
Yes, my lord. Yes, my lord.
Opposite.
I represent the petitioner, defendant, tenant in a suit for eviction under the provision of West Bengal Premises Tenancy Act 1956. The impugned order is there were not any speaking order so far the section 17(3) is concerned under the provision of Act 1956. We have filed an application, one application, that the area of rent payable by the defendant has not yet been calculated by the learned court, and the defendant has not been given an opportunity to pay certain amount payable by the defendant within a certain period. If that was fixed, then certainly the defendant, if failed, then the question of section 73 will come into play. I have filed my application under section 17(2) and section 5. All are rejected from time to time. And the suit has reached the stage of cross-examination of PW1.
So what do you want?
I filed two applications. One application to decide the quantum of rent or area payable by the defendant, and to decide the relationship of landlord and tenant. And second application is to permit the defendant to cross-examine on all the points. That is, two applications have been rejected by the learned trial court. My contention is this: till this date, no order has been passed by the trial court to decide that the relationship of landlord and tenant prevails, and the quantum of amount payable by the defendant to the plaintiff.
You filed a 7(2).
So that was rejected a long time ago.
Chale.
Then my question is whether so far the section 72 is concerned, application may be rejected, but the defendant has a right under the provision of section 72 to pay the amount if the learned court calculates the amount of rent. If the learned court holds that yes, there are the relationship of landlord and tenant by and between the parties of suit. In a written statement, I have raised that plea. But there are not any order on merit that yes, there are the relationship of landlord and tenant by and between the parties to the suit, and the amount to be paid by the defendant. So my contention was that I filed an application. It is the duty under the Act 56. It was the duty.
The suit is governed under the 56.
56.
So determination of relationship is there in 17.
Yes,
In 7(2) also there is there.
Whether I am stopped to raise this point if my defense is stuck out. Even at the time of defense stuck out, I should be given the opportunity of being heard. Even at the time of disposing of the application, there are not any application under 17(3). But the court, learned trial court holds, and the plaintiff tried to convince the learned court by holding, no, your application 72 has been rejected, section 5 has been rejected, automatically 73 has come into play. My condition is no, in that case. Even you filed an application under section 73, I may file the written objection on, and that application was required to be considered on merit. In that case also, I have the opportunity to deny the relationship of landlord and tenant, and also deny the amount payable by the defendant. But the learned trial court, two applications, the learned trial court has rejected the two applications against which I have come up before your lordship for revision. Your lordship will find the written statement in page 23. My written statement.
স্যার বলা হয়ে যাক
Defense was struck out.
They are saying on the basis, without any application, on the basis that as the 72 has been rejected, section 5 was rejected, automatically 73 are coming to play. That is the contention of the trial court also. And there my objection is this: the 70 in the application of the section 70, if any, then certainly I may be given an opportunity to file the objection. But the issue of relationship of landlord and tenant has not yet been determined on merit. Amount payable by the defendant has not yet been determined. Because so far the Act 1956 is concerned, there are no question of rejection of the 72 application.
But there has to be a determination by court about the rent payable, isn't
Yes.
it?
my lord, may I answer, my lord?
Yes, ma'am.
Now, my lord, the law is well settled on this aspect as of date. My lord, 17.2 or be that as it may 7.2. My lord, it has been found both are parameteria to each other. My lord, the preconditions of 7.2 and 17.2 are same. My lord, it has to be accompanied by the admitted areas of rent. If it is not paid, my lord, the 7.2 is liable to be rejected. And my lord, there is no question of section 5, my lord, condoning the delay. Now, if my lord takes up, my lord, the contention of the defendant is that, my lord, initially, my lord, in the application which is filed under consideration before the trial court, my lord, takes up the application once. What is the application? Kindly takes up page 28. My lord, this is the second application, I would say.
Hmm.
My lord, the third paragraph, that it appears from the record that he has not filed any application under section 17.2 or 17.2 AB of the Act 1956. And on the contrary, the appointed learned advocate of the defendant number 1 filed an application under section 10 of code by stating that the defendant number 1 along with other occupiers of the premises jointly filed a title suit with a prayer for declaration, and the instant suit is required to be stayed. But on hearing, the learned court was pleased to reject the said application of the defendant. So therefore, previously, my lord, an application was filed saying that I am not entitled to pay money. That application, though not nomenclatured, maybe not nomenclatured, that application is not annexed. My lord, the court has found from the impugned order, my lord, will find from record, those applications were rejected, permitting the defendant either to deposit or, my lord, saying that they are not entitled to deposit. My lord, those
But
orders,
I think which page 28?
28, the third paragraph. My lord, if side by side, my lord, takes up the impugned order internal page 2, my lord, those applications, court specifically refers, my lord, those applications under 17.2 nomenclature with section 5 was disposed of on 1st of April 1999. And subsequently, a recalling application was filed, which was also rejected on 15th of April 2004. So therefore, my lord, today, if my lord sees the prayer of this application, my lord, which I have just shown at page 28, my lord, the issue of relationship landlord and my lord, whether what amount to be payable, my lord, has already attained finality, and my lord, this application is now barred by res judicata. My lord, law is settled, my lord, in intra proceedings also, my lord, res judicata applies. My lord, if he doesn't challenge those orders, and my lord, 33 years have passed, my lord, he cannot come up, my lord, those issues which have been set at rest. My lord, he has not traveled up to challenge those orders. My lord, he cannot have the same relief, my lord, which has already been rejected by the trial court, my lord, after 33 years.
So therefore, the question of res judicata would come into play.
When was the suit filed?
The suit was filed in the year 1990. Not exact date, most probably. It's numbered as 281 of 1990.
This application and the 7-2 was filed?
My lord,
17-2?
the original application is not annexed. I have asked my counterpart to
98.
90. It was dismissed on 1999. But probably not at that
No,
time.
this 28, page 28.
28.
This is
Sir.
the application which was rejected.
1998. This is the
Ah.
application I have annexed 1998.
1998.
This must be the first application.
Probably, my lord.
Where is the next application?
Now, my lord, next application, my lord, takes up at page 34. This is subsequent 151 application by which they have come up. Page 36, the prayer. Kindly seize the prayer. My lord, he prays for deciding the amount. Same. But this cannot be done. Absolutely barred by res judicata on the face of it on one point. Second,
Where is the 17-2 order? Do you have?
my lord, that I have asked my
order?
learned friend
Dismiss
to
for
correct.
default. Not correct, dismiss for default.
My lord, court
And that-
records something from
and several
perusal of
times-
record, it is found. My lord, if court records
And
something, my lord,
defendant-
I am not to disbelieve the court.
Not on
Submissions may be
contest.
erroneous, but recording on perusal of record, it is found. My lord, as the records are very old, I have asked my counterpart to get hold of these orders, and he has deliberately, he is filing the revision. He ought to have annexed those orders. If he is challenging those orders, the recording is wrong. And if the recording is wrong, my lord, I would say, my lord, let him go back to the trial court and correct the recording. Instead of, my lord, not placing record before the court and agitating those recordings are wrong.
The thing is that was the court justified in rejecting the 17-2? Or should have the court determined the fair rent?
Court has no, my lord, there is no law that once it is filed, my lord, there are certain old decisions, my lord, which said that once 17-2 has been filed, court is duty bound to dispose it of. This was the old theory.
Not to
But
decide them.
after my lord Chamaria, my lord, the law has changed category.
Maria says delayed deposit not be allowed.
Absolutely, my lord, court record, it was his section 5 and my lord, that is on record. He has annexed the section 5 application.
Now, that was earlier. Then
So
somebody
therefore, my lord,
else-
section 5 is not allowed in 17-2.
No, that is from within a month from receipt
So
of
he has,
summons.
yes. My lord, he has filed much after that. That's why section 5 he has come up with.
No, subsequently no section 5.
No, this is 151. Well, subsequently, what has
In
been
1990, Chamaria was not there.
maybe, but today when my lord is considering, my lord will consider the law as on date. Well, even the court has decided the issue on date. My lord, Chamaria has not said that the law has been created today in 2019. It was there. BP Khempa was the, my lord, judgment by which we use that it was discretionary. We got leaves from court to do that. But after Chamaria, my lord, there is no discretion left.
No, but once your 17-2 was rejected in 1998, in 2000, এটা কবে filed হয়েছে?
My lord, this is filed sometimes. It a file question verification 2023.
Then
Page
15th March.
33.
March 23.
My contention is only very modest. My prayer is this: 17-2 West Bengal Premises Tenancy Act 1956 is for protection of tenant against eviction. So far, my condition is this: if the defendant, whether the defendant has right to get an opportunity to pay the amount or not.
Have a right to protect your tenancy by paying the money
But
within the time fixed by the law.
but that is to
Or
be
at that point of time, maybe extensions
that
could
is to be
given
decided by the landed
by
court.
section 5.
That is to be decided
And
by
the
the
court
landed
has
court.
decided.
But landed court has not decided the amount to be paid by me.
Reject করে দিয়েছে।
And
No, that has been
Then
rejected.
you have rejected.
Rejected.
but not on merit.
Then why didn't you do anything for so many
And there
years?
were several applications have been done.
What applications?
There are for condonation, for modification, everything. But
Where?
now,
Take down.
as well, ownership pleases.
The petitioner is agreed by an order dated April 11, 2023, passing title suit number 281 of 1990. By the said order, the learned civil judge, Junior Division Second Court at Shialda was had rejected two applications filed under section 151 of the Code of Civil Procedure dated March 15, 2023, filed by the defendant tenant. The title suit is a suit for eviction. By the application under section 151 of the Code of Civil Procedure, the tenant sought to approach the learned court below to decide, by one of the applications, to decide the issue of the relationship between landlord and tenant, and also the quantum of rent that may be paid by the tenant upon condonation of delay. The said application was filed on March 23, 2023. March
15.
2023. Along with the aforementioned application, a further application was filed to allow the tenant to cross-examine the PW1 on all points. The said both the applications were dismissed on the following, rejected on the following grounds. A, the application under section 17(2), A and B, small a and small b, no?
Small. 72,
Was
first
already
capital A,
rejected by the court
my lord.
of the West Bengal Premises Tenancy Act 1956.
প্রথমে ক্যাপিটাল
First capital A, then small a, small b.
capital 2a, thereafter within bracket small a, small
17(2),
Capital A,
capital A.
A, 2A,
capital,
তারপরে small a
small.
and small b, had been rejected sometime in
99 মিলট এপ্রিল কত এপ্রিল ছিল জানো
on 15th April 20
নো মিলট 1st of April initially, then
1st April 1994. Again, the defendant tenant filed an application under section 151 of the Code of Civil Procedure for restoration of the order of rejection. For restoration of the application. For modification of the order of rejection by an order dated April 15, 2004, the order of rejection of the application. Now, the said application under section 151 of the Code of Civil Procedure was rejected on merits. The defendant did not prefer any revision against the said order, and the order rejecting and the orders became final. After 33 years from filing of the suit, the defendant once again prayed for determination of the rent and the relationship of landlord and tenant under section 17(2) of the old Act. The learned court found that the intention of the defendant was to delay the time to delay the eviction suit and refused to grant any further extension of time either to pay the area rent or to decide the question of, and also refused to decide the question of landlord and tenant. But Mr. Chatterjee, defense to be struck out that you should file an application.
No, Milord, is not required under law.
Not required.
Not required. Milord, I can file. Court has suo motu power to strike off the defense. Milord, that's the provision.
There is no order striking out defense.
Milord, this is the order. Milord, court specifically says in this order, for non-compliance, your defense goes under.
Where is that?
Milord, kindly sees. Milord, first of all, sees. Milord, the first page of the impugned order. It is the submission of the defendant. Milord, the defense has been struck off. Milord, first, second paragraph, the defendant submits before this court. Then kindly bottoms down, Milord, from the sentence, but both the petitions are rejected by this court and the defense of the defenses has also been struck off. Milord, after the defense has been struck off court records. Milord, therefore, Milord, the issue boiled down to whether he is entitled to cross-examine on all points. My lord, court
That application we
Yes.
filed.
But that application is at page. Huh. That kindly turns to page 41. And the prayer, page 46.
On all points, I've seen. What is he stated?
My lord,
What has he stated in this?
in this, my lord, the 7-2 has not been, 17-2 has not been decided. I have a right. My lord, all these things. And my lord, court. And the court records, my lord, that non-compliance now, my lord.
My lord, maybe permitted to submit, my lord. In 17(4), there are the provision that if the defendant complies with the provision of 17(2) or to pay the said amount, then we'll get the relief under section 17(4) of the WB Act 1956. Then what is the 17(4) of the Act 56 saying? If the defendant fails to make the payment, 73 also in 56 Act, if the defendant fails to make the payment, and 17(4),
Go to page 43.
Yes, my lord. My lord, 43.
If the defendant gets a right of so and so, so and so,
My lord, these are his submissions.
directed.
The judgment has been quoted, my lord. In para 57, honorable judge held that there is no ground at all holding the right of. Yes, my lord, I've seen that, I've read over. My lord, he has quoted several decisions when defense is struck off, what will happen. My lord, and my lord, the honorable trial court, my lord, learned trial judge has categorical that if the defense is struck off, my lord, you are not entitled to a cross-examine on all points, and that's the settled law by Supreme Court.
Now that is true, but I'm saying that there is no order in writing that the defense has been struck off.
My lord, then, my lord, may I just, my lord, make my humble submission. My lord, suppose, my lord, in a situation, my lord, there is no formal order. My lord, kindly considers this stage before Chamaria. What was there, my lord? Court was also always of the view, my lord, there has to be an application under 7.3 or 17.3 for striking of defense. When Chamaria came in, my lord, I brought that and I rely upon that. Chamaria said it's automatic. Now, my lord, if I link Chamaria's view with, my lord, 1987 CHN, my lord, where, my lord, Mr. Dasgupta argued, my lord, before the honorable court, that there is a question of waiver. My lord, you dispute relationship of landlord-tenant and you do not choose to file 7.2 or 17.2. You waive your right. My lord, then what is the consequence? Consequence will follow under 17.3 or 7.3, whichever. Chamaria comes in and say, it's automatic. Now it's only a ministerial job which is left to the court. And court, by this impugned order, defendant himself goes and says, my defense has been struck off. Court also says, yes, your defense goes. And as your defense goes, court explains, now you have only right to cross-examine on notice point. My lord, I would say, my lord, this order records defense being struck off. My lord, if that be so, that ministerial job is also over by this impugned order. Today, what is the consequence? If my lord says there is no order on record, my lord, tomorrow the court will pass an order, the defense is struck off. My lord, its effect is same. My lord, if from this order it is evident, my lord, his defense has been struck off.
Wait, let me read the order. Yes, place that part order.
Yes, my lord. My lord, I am reading from internal page 2. On perusal of the case record, this court opined that this is a suit for eviction of tenancy filed by the plaintiff against the defendant, and it is pertinent to mention herein that the Section 5 application and petition under 17.2 of the West Bengal Premises Tenancy Act 56 was disposed on 1st April 1999. And again, defendant filed an application under Section 151 of Code of Civil Procedure with a prayer to restore the previous rejection order, but on 15th April 2004, this court had again rejected the same application on merit by order number 68. However, the defendant did not refer any such provision, any such revision application to the upper forum
against the aforesaid rejection order passed by this court on 1st April 1999 and 15th April 2004. After passing of 33 years of the suit, this defendant wake up from his sleep and again prayed for before this court for determination and adjudication of 17(2) application under the old act when the suit has been running in peremptory board. The intention of is very clear to this court that the defendant has an intention to kill the valuable time of this court by filing petition one after the other on the same ground. In AR 1989 Supreme Court, it was held that even in case where the defense against delivery of the tenant is struck off, Lord, court is going into that issue. Under section 17(4) of the act, the defendant, subject to the exercise of an appropriate discretion by the court on the facts of a particular case, would generally be entitled to cross-examine the plaintiff's witness to address the argument on the basis of plaintiff's case. But it is clear that the defendant would not be entitled to lead any evidence of his own, or can cross-examine be permitted to travel beyond the very limited object of pointing out the falsity or witness of the plaintiff's case. In no circumstances should the cross-examination be permitted to travel beyond this legislative scope and to convert itself virtually into a presentation of defendant's case, either directly or in the form of suggestion put to the plaintiff's witness. In view of this court, when 17(2) of the applicant filed as defendant has been rejected, it is very clear the prayer for the defendant has also been dismissed by this court, as there is no force of the prayer for 17(2) application.
Can we assume by this court that the defense of the has automatically
Is
struck
struck
off
off.
for the provisions
Yes.
of law? Defendant has no right, yes. Yes, take down. Ki bollam?
I ask myself the question, the issue in the WS, whether the plaintiff, there are the relationship of landlord and tenant has automatically been determined, presumed.
You had the option 17(2)
But
rejected,
if it is, but
modification rejected,
but
need not
if
go
it-
the higher forum.
but
Matter is,
if it is in the written
Yes.
statement, but if it is in the written statement, in the written statement, the plea is
Bolna-
this.
yes. And also refuse to decide the question of the question of the relationship between landlord and tenant. ঠিক আছে? The court was of the view that the petitioner had slept for 33 years over his right to challenge the order of rejection of the 17(2) application. But suddenly the petitioner could not wake up and pray for a redetermination of the issue which had already closed. Next, the court was of the view that the situation, next the learned court held that the petitioner not having availed of any remedy in terms of section 17(2) of the West Bengal Premises Tenancy Act at the appropriate stage and in the appropriate, before the appropriate forum, the same would amount, such inaction would amount to the defense being struck out. Shall amount to the defense being struck out. The relevant portion of the order for clarification for convenience is quoted below. In view থেকে এখান থেকে page 3. এই অবধি করে দাও। Next, the other application was also rejected by the learned court below upon inter alia holding that the defense having been struck out, the law was clear. Reference was made to the decision of the of this court in decisions of this court inter alia stating that once the defense is struck out, all that the tenant is entitled to, the tenant would only entitled to cross-examine the plaintiff's witness and address arguments on the basis of the plaintiff's case. The cross-examination would not travel beyond the
No, this is the citation, my lord, may take it. It to the Kindly takes up paragraph 17 of this decision,
17.
internal page 4640.
And or the cross-examination limited to the cross-examination of plaintiff's
That
witnesses
would be
and
relevant.
address arguments on the basis of the plaintiff's case without leading any evidence and without bringing anything on record which was beyond the case of the plaintiff. ঠিক আছে? Upon finding that the defendant could not give any explanation as to why the issue of the 17.2 could not be raised earlier and before the appropriate forum after its rejection on merits, subsequent rejection on merits, the court refused to entertain the applications filed under section 151 of the Code of Civil Procedure. Next paragraph. Having perused the documents and the factual aspects which have been gone into by the learned trial court, it appears that no further opportunity can be given to the petitioner to pray for deposit of arrear rent and restoration of his in order to avail of the provisions of section 17.4 of the West Bengal Premises Tenancy Act 1956 in view of the settled position in Bijay Kumar Singh versus Amit Kumar Chamaria, reported in Dash, wherein the Honorable Apex Court has clearly stated that a plain reading of section 7.1 of the new Act, Premises Tenancy Act 1997, clearly left no space for the court to condone the delay in deposit of rent. The provisions of section 7.1 and section 17.1 of the West Bengal Premises Tenancy Act 1956 are pari-materia, and at this stage, after 33 years, and after rejection of the first application under section 17.2 of the West Bengal Premises Tenancy Act 1956, the point cannot be reopened, especially because the petitioner did not move any higher forum against such rejection. Secondly, the law is well settled with regard to the scope or with regard to the opportunity that a tenant can have once his defense is struck out. Relevant paragraph decision is that it reported it. The relevant paragraph 17 of the
17, and my lord, the guidelines were framed, my lord, from paragraph
14.
No, my lord, 20, 21 and 22 are the safeguards created by the Honorable Supreme Court. And my lord, 24, what has been quoted by the Honorable Learned Trial Judge, paragraph 24. 17 clearly postulates the law is settled that only on the notice 13.6, there has to be cross-examination. And my lord, if my lord takes paragraph 20 onwards, these are the safeguards. Because if cross-examine, what was my learned friend arguing? Exactly, the court was of the view, if cross-examine is allowed, he may tender documents, my lord, to beyond the plaintiff's case. Therefore, these were the safeguards.
Now, the relevant paragraphs are quoted below. For 20 থেকে এখানে এটা দিয়ে দাও কোর্ট চেম্বারে করে দেবে।
And my lord, paragraph 24 is the penultimate, my lord, what has been quoted in the learned trial courts. Paragraph number 24, what has been quoted by the learned trial.
24 is the final
Final,
decision.
final.
And ওখানটা লিখে দাও যে thus in view of the above mentioned decision as well, the petitioner cannot examine the plaintiff beyond the law which is well settled and on additional issues or on additional either on issues beyond the scope of the plain case or on additional issues, nor can the petitioner lead evidence in the suit. The order impugned itself records that the defense itself can be treated as an order striking out the defense of the tenant.
My lord,
Shall
my lord,
proceed on the
my lord,
limited point of cross-examination on the limited points as already decided by the learned court below.
my lord, may I be permitted to submit?
The application is dismissed. Yes.
The defendant have the liberty to argue of the plaintiff's case.
Yes. Yes, that you
That
have.
may be.
That is there in the trial court
Your
order.
Lordship-
Arguments on the plaint case can well be
Yes,
advanced
my lord.
and no further, and the learned court below has not denied such opportunity to the petitioner.
We should defendant.
Petitioner is a defendant.
Defendant.
Now we have to pass over আছে ওটা ডাকো।
মানে এটাতে কি বলবেন জাজমেন্ট দিয়ে দিন হাইকোর্ট দিয়ে দিয়েছে বা জাজমেন্ট দিয়ে
না না
দিন।
ক্রস এক্সামিন তো
এইটুকু লাইন আমি গিয়েও বলে তো জাজমেন্ট দিয়ে দিন বাস অর্ডার হয়ে গেছে বললে হবে মাই লর্ড।
I'm for the petitioner, my lord. Very short matter, I will not trouble your lordship. My lord, there is no scope for interim order. My lord, this is a challenge to an,
Let me see.
Lord, kindly takes up the impugned order, my lord.
Challenge to
An application, my lord, I made an application under order 26, rule 9, Lord, which is appearing at page 102. My lord, kindly sees the nature and scope of my application once. Now, this is for appointment of an engineer commissioner. I am the landowner, the opposite parties are the developers. Now, Lord, we enter into a joint venture agreement. Lord, page 104 is, my lord, the
1 minute. So because the High Court ordered, appointed a special officer, the order was recalled. Appointment was recalled.
yes.
Hmm.
Now, the dispute, my lord, with lordship will find, my lord, special officer, my lord, can do only certain acts, but he is not expertised in engineering. Here, the actual dispute lies, my lord, there are developers allocation and owners allocation. So now, my lord, they have entered into or encroached into, my lord, the owners allocation. And, my lord, there are structural deviations as well, which only, my lord, an engineer, my lord, who is, my lord, has the knowledge, sound knowledge of this can,
What is the suit for?
The suit, my lord, essentially is for, my lord, a declaration suit filed by, my lord, them, the opposite parties.
Hmm.
Now, this
Saying
matter,
what? Saying what?
my lord, the scope of the suit, my lord, specific prayers, my lord. No, this says. No, this is a suit for specific performance of contract and for injunction, like paragraph 14, which were filed by them.
What was their allegation?
My lord, their application, my lord, is for specific construction, my lord, performance, my lord, restraining the defendant and the men from causing annoyance and disturbance in the peaceful business area or at their places of employment, and restrain the defendant and the men and agents not to send an email or letter to any office premises of the plaintiff's office. Thereafter, my lord, the temporary injunction was allowed. From that, my lord, they preferred an appeal. But we preferred an appeal, first miscellaneous appeal, my lord, that is at paragraph 15.
What is your application
Not application,
for local investigation?
no, that is at page 102. And my lord, my schedule is in 104, my lord, the scope of investigation. My lord, kindly see, my lord.
But this was rejected once.
No, this is the fresh application. This is rejected. From where, my lord, initially I preferred an appeal before the division bench, wrongly. My lord, I withdrew it. Now, my lord, I've come before this court. Because this is not an appealable order under order 43.
Why will these things be seen in that suit? They are not relevant at all in a suit for specific performance.
A suit for specific performance of contract, they obtain an order of injunction. Thereafter, my lord, we go up in appeal. In appeal, my lord, then there are contempt proceedings, orders passed by this
But
court.
you what local, whether there is deviation, whether there is construction, why should that be seen?
It
That
has,
is, and that is not for local order 29 rule 9 at all. Take down. The
because
petitioner-
otherwise, my lord, there will be no remedy left. Because now, my lord, the flats are being
What
constructed.
remedy you want?
Look.
You have to execute, whether you are bound by a contract or not is the subject matter of the suit. So whether what is the multi-story building looking like? What is the,
No, my lord,
those
this-
things
the-
are not
the
relevant. at all.
primary dispute here is with regard to the allocation.
No,
I
where
say
is-
that, my lord, I have been allocated less area. They say that they have allocated the,
you show?
now, my lord,
You
no,
can't fish out evidence.
otherwise, my lord, without there being an engineer expert, my lord, there cannot be, because special officer, my lord, to limited extent whether the flats are handed over. That was the view of the
Second,
court.
the reasoning, but these are not relevant for the dispute, and this is fishing out evidence. Take down. This or 20, whether 26 rule 9 is not required for this. To see whether plaintiffs have lawful authority and permission and license, this is scope of 20 order 26 rule 9. Take down.
Perhaps, my lord, it's not in the appropriate form, my lord, but the
No, no.
crux, my lord, is whether
Petitioner is aggrieved by the order passed by the learned Civil Judge Senior Division Third Court at Barashat, District 24 Parganas North, dated August 17, 2022.
22.
By the said order, the learned court below recalled the writ issued to learned advocate Farooq Khan, who was appointed as a commissioner to conduct an investigation of the suit property on the basis of a prayer made by the petitioners. It also appears that the reason for recalling the writ was that a learned special officer had already been appointed by the High Court in an appeal, and the special officer had submitted a report. The learned court rejected the application on the ground that did not permit local investigation, on the ground that a further local investigation would amount to conflicting decisions, and the learned commissioner would not be directed to investigate further in respect of the deficiencies in the report of the learned special officer. The petitioner is the defendant in the suit and owner of the suit property situated at LR Dag number 1312 of Moja Rohora under Khordha municipality. The petitioner, the plaintiffs and the pro forma defendants are the developers who entered into a development agreement. Disputes arose and the suit for you. Where is the plaint?
The plaint is not annexed, my lord.
Acha,
I have checked up, my lord. Development agreement, power of attorney, my lord, these are annexed, but the
All right.
plaint.
The suit for
Specific performance of
performance
contract.
of contract was filed, being title suit number 459 of 2022 in the court of the learned civil judge senior division at third court at Barasat. An order of injunction was also. What is the nature of injunction?
No temporary injunction, my lord. Restraining, my lord, the
Restraining the
defendant, my lord, that is the petitioner here.
petitioner from
My lord, from kindly see paragraph 14, my lord.
the developer are not relevant for adjudication of the dispute in the suit for specific performance of contract. Thus, this court is of the opinion that the application was not maintainable and the learned trial judge rightly rejected the prayer for local investigation. The reasonings may not be happy, but the ultimate conclusion of the learned trial judge is correct. Hence, conclusion of the learned trial judge is correct. Hence, there is no scope for entertaining the revisional application. Stop. The revisional application is dismissed. Let me see if I can find one or two cases against you. I will incorporate that. পরে চেম্বারে গিয়ে দেখতে হবে।
There's no scope because, my lord, if it was my suit, then I could have prayed for. The basic principle is I cannot pray for any specific prayers in somebody else's suit. Not I had said so, but your lordship knows.
Oh, that's okay. চলো ডাকো, খাবে না? খিদে পাইনি। আবার কি হলো? Have you seen the clock?
Lunch complete হয়ে গেছে। Lunch complete হয়ে গেছে।
Give me a break.
With utmost humility, may I mention one?
Yes.
List shows that the applications will be taken up from 3 p.m. I have an very urgent motion which is listed at item number 42. Could it be placed tomorrow fairly at the top, because the next date fixed before the Rajarhat Commercial Court is on Monday, that is 12th. Rajarhat Commercial Court on 12th, that is Monday.
Let me see how far I can reach. Tomorrow it will be in the,
Now, since it is at 42 and the list shows that from 3 p.m. applications will be taken up, I did not disturb in the morning because I know.
do you have any opponent?
No, there's no caveat, madam. My adjournment petition stood rejected subject to payment of cost of 1 lakh. I have challenged that. There's an order at section 15, my lord, zone order, SARKAR, stating that once we come from suit court to regular court to this one, the same thing. That is why I've just made a mention. If it's appealed, I can do it today, or if it appeals.
So wait till come at 4:30.
Malhar, come. Sure.
But you have to serve notice.
But there's no caveat. This is the first time this is a motion.
No, but if I interfere now,
Well, at least for 7 days or 10 days, whatever my
what
lord.
have they given you? What?
I had filed 3 applications, my lord. One of those applications was an adjournment petition alleging that my lord, when I had filed a written statement at Barasat, it was time barred. Subsequently, I took advantage of section 15 of the Commercial Courts Act and had again filed. And then he says that this entire 6 pages order, he writes everything. And the last line he said, all against me. Then he says, okay, you pay 1 lakh rupees subject to payment of cost. This will be stand allowed, and next date is on.
So when the Barashat court kept it on in the record.
Yes, that time, but it has been transferred commercial court on the very initiation, and now he has rejected with say.
It was transferred subsequently.
Yes.
Then you file an application here for acceptance of the WA.
Yes, all were there, all were there. On he dismisses and he states that
42 to একটা order record করো. Service of the revisional application upon the
one sole defendant, only one.
What can I give you? I have to just reduce the 1 lakh. That is what you want.
Reduce 1 lakh, one. I wanted stay of the order, but
What is the claim?
My claim is 6 crores 9 lakhs. Then we have filed our written statement. I was appearing. I was appearing for the Kolkata Municipal Development. I was a defendant there. Here I have come up as a
let this matter appear on. Who is the opponent?
Well, I'll serve this. No. Opponent Ukile Nam.
Plaintiff, the claimant. Who is the plaintiff?
Well, SMS Limited.
privately.
Where do they stay?
Delhi. I'll serve them.
Pune.
Pune. Yeah, Pune. I'll serve them. Entire copy of the revision. 12th is the date fixed, my lord. If I pay 1 lakh, he will take it up. If I don't pay, my this is the discussion. Keeps it a week later after.
Why you can't pay 1 lakh?
1 lakh for rejection of my application for adjournment, where I filed my written statement. Some 6 pages order gives me 1 week or 2 weeks time.
Right.
Sir, I'll come back.
Let this matter appear in the supplementary list on 26 June under the heading new motion. 26 on late. 22nd June under the heading new motion. Stay of all for the proceedings in commercial suit. Number.
Well, I'll give the number.
Just give the pending before entire thing up to 30th June. I mean, if you see, this court is of the view that
145 of
the imposition of cost of rupees 1 lakh may not be totally justified unless the opponents are heard, may not be justified, but unless the court hears the adversary, it would not be possible to record the justifiability of the order impugned. Yes.
The money suit 145 of money suit 145 of 2008.
Opposite party.
So only one.
And also the learned advocate of the opposite party conducting the case in the commercial court. Give him a copy, come back. Yes.
I'll kept it on 22nd.
22nd June.
Stay in the meantime.
Yes, up to 30th June.
Oh. 42 number. KMDA versus SMS.
42.
পরে দেখো না item number 42 এখন listed হবে
Well, great.
Yes, madam. For the petitioner plaintiff, madam, I have filed a suit for declaration and permanent injunction before the learned trial court. The case is that my father has gifted the property upon me and my younger brother also. By way
What
of,
is your challenge?
no, man, there is no challenge at all. I am
Which one?
expeditious trial, man.
Which one?
The shoot, that will shoot 98.
No applications are pending?
Only order 30 and rule 7 is pending, but the case is that the learned trial court, each and every occasion, the defendant has.
Temporary injunction disposed of?
No. Till now,
So what are the applications pending? That is what I'm asking you.
temporary injunction hearing is pending because status quo has been granted and order 30 and rule 7
and
other applications also pending each and every occasion. the
other
people-
আর কি কি আছে সেটা you tell me.
Only order 30 and rule 7, my lord, and injunction application.
Only two? Only two?
Only two.
Take down. The petitioner is the
Is a plaintiff, my lord.
is the plaintiff in a suit for
Suit for declaration and permanent injunction
declaration and permanent injunction.
of illegal construction by the.
All right. The title suit number 98 of 2021 pending before the learned civil judge junior division second court at Barakpur. Petitioner praised that title suit number. Be expeditiously disposed of. The petitioner submits that some applications, an application for temporary injunction as also an application for local inspection are pending. It is further submitted that the ad interim order of status quo
Status quo, my lord.
is being
And it
is
has
being
been
extended from time to time.
Yes.
Is being extended from time to time, but the application the main application is not yet disposed of. Written objection, written statement filed.
Yes.
It is further submitted that the applications are ready for hearing and written objections have already been filed. Next paragraph. As a petitioner has made an innocuous prayer for expeditious disposal of the pending applications as also the suit, such prayer, if allowed, such prayer, if allowed, would not cause any injustice to any of the parties. Rather, expeditious disposal shall inure to the benefit of all. Under such circumstances, without going into the merits of the applications and the suit, and without making any observation on the right title and interest of the petitioner in respect of the suit and the claims of the petitioner, the reliefs claimed by the petitioner in the suit, this revisional application is disposed of with a direction upon the learned civil judge junior division second court at Barakpur to dispose of the title suit number so and so along with the pending applications expeditiously. The pending applications must be disposed of within, where is the next date fixed?
Next date
Within
fixed on
3 months from the
18/7/2023.
next date fixed. And thereafter the suit shall be disposed of within the following 12 months. A copy of this be served upon the opposite parties, along with the server copy of this order. Yes. 3 months application, 1 year suit. Next.
Item number
Not today,
next week, my lord. Any day next week, my lord.
then not this week.
Next week.
Taratari doc.
Lordship, I am appearing for the opposite parties. I have instruction to Lordship appear on behalf of the opposite parties. I have received the Wakalatnama also.
Give him a
But
copy.
there is
come
no
back to
caveat,
next week.
Lordship.
All right. Do I have to record an order?
Not necessary, Lordship, if they supply the copy.
Mr. Dutiman Banerjee.
Sarvananda Sannal,
Oh,
Lordship.
Sarvananda Sir. Mr. Sharnal, learned advocate, appears on behalf of the opposite parties and seeks for a copy of the revisional application. Let such copy be served upon Mr. Sharnal within the course of this week. Let the matter appear on Monday. 12 tarik.
Great.
12.
12. I'm great.
Wait for some time. I rose at 2:15 in the first half, so just please. They want a copy, let them come back on Monday. Yes, next. You also went to Himachal Pradesh? Birgo?
A little longer distance. I went to California.
You went to California? Yes.
May I please, Your Lordship? Your Lordship, if the item number 21 and 26 are with regards to the same parties and the contentions are the same.
What
If the
is your 21?
21 is regarding rejection of an Order 7 Rule 11 application.
Hmm.
I am the petitioner defendant
Hmm.
in a suit for declaration, recovery of possession, damages and permanent injunction. Now the 21
My lord, I have instruction. I have
Dada.
filed caveat.
Wait.
yes.
Call him. Call your senior.
In the
My lord, we
application
have
was
not received the copy, my lord.
Nothing you.
there was no caveat as per my instruction.
Call him.
Obviously caveat.
The grounds agitated in the
Yes,
order,
there is a caveat.
then I'll serve copy.
Wait 1 minute. What is the suit for?
The suit is for declaration, recovery of possession, damages and permanent injunction.
Why you file Order 7 Rule 11?
Because the suit on two grounds, on three grounds. One, there is no cause of action. The important one is this: it is barred by the law of limitation, clearly barred by the. Because Your Lordship, if Your Lordship kindly takes up the plane for once,
Yes.
it is at page 23. Starts at page 23. Lordship kindly comes to page 25. Now, from their admitted position, I'll show to Your Lordship that the suit is barred by the law of limitation. In paragraph 4, at page 25, paragraph 4, the plaintiffs state that there was an execution of a memorandum of agreement
On
in
1993.
1993, Your Lordship. Yes. In that said, then if Your Lordship comes to page 26,
Suit was
paragraph
filed in.
2021, after 29 years.
Serve him.
My lord, item number 4. Kindly, my lord, not today, my lord. Let us copy be served, my lord.
I just said serve.
My lord.
Yes, service upon the of the revisional application upon the upon Mr.
Post of Bhattacharya, my lord.
Asta Bhattacharya. Let this matter appear on
Monday, Tuesday, any day, my lord.
Monday.
Monday.
12 तारीख. Under the heading new motion.
Your
Yes.
Lordship, item number 26 is also regarding the same, exact same. It's an analogous to analogous suits.
26 also.
To analogous suits.
21 and 26 the same order, alada record হবে. Yes, call the next matter.
I'm grateful.
Hmm? Yeah, Baba.
22, I'll appear for the petitioner, Lordship. Lordship, I'm aggrieved. I'm the plaintiff in a suit for eviction. Lordship, I'm aggrieved by an application, an order whereby an application by the defendant under 151 was allowed, thereby permitting him to pay one of the current monthly rents after a period of almost 1 year. Lordship will kindly take up the impugned order once. They were paying the rent from month to month, but for 1 month, that is for September 2022, 21, they had not deposited the rent. For September 2021, an application under the provision of 151 was taken out in August 2022. And that has been allowed, Lordship.
Chamaria says even subsequent deposits have to be on time.
Subsequent, Lordship, it has to be because it is no more discretionary, it is mandatory. And there is even considering that it can be, there is an outer limit of condonation for
2 months.
2 months. So that cannot be condoned after a period of 1 year almost. Exactly after 1 year, they have taken out that application, and also under 151. When there is the 151 will have no application here. Chamarias makes it absolutely mandatory and no more
Let
leaves.
serve and come back.
Yes.
Service upon the opposite parties. As also the learned advocate for the opposite parties conducting the case, conducting the suit in the case below. Let the matter appear in the list on Shatash under the heading new motion.
Deeply obliged. Great.
There's no need for any
No
stay.
need for stay. I'm not great. My suit. Great.
Yes. Shatash.
Lordship, I am for the petition. Lordship, I am praying relief by challenging the order dated 21st of April 2023. Kindly see the order, Lordship.
This is the ground on the ground of what?
Lordship, on the ground of limitation, Lordship.
Co-sharership, preemption.
Preemption co-sharers, Lordship. Co-sharership.
Then
Lordship.
he's saying he's a non-notified co-sharer. What is the limitation?
Lordship.
Then
Lordship,
4 months,
the Lordship.
7 months is all right. 1 year, the non-notified co-sharer.
Lordship, 4 months.
Yeah.
4 months, Lordship.
Their plea in this, when you ask this to be decided as a preliminary issue,
Lordship.
their plea was that he's a non-notified co-sharer.
Lordship.
So the court said that this is a question which has to be proved in trial. What is the wrong in that?
But Lordship, plaintiff came know this fact very very.
How do you know
Lordship,
that?
kindly,
So
kindly
that
see-
is a matter of evidence, isn't it?
Lordship, which is mentioned in the plain copy, Lordship. The which is admitted also by the learned court below, Lordship. Lordship, plaintiff did not file limitation application and also did not specifically
It is not applicable. Section 5 will not apply anymore.
in respect of this matter.
In a preemption case,
Lordship, section 4 is applicable in respect of this matter.
section 5 is not applicable.
Not section 5, no, Lordship. Section 8 of the West Bengal Land
You are
Reforms Act.
saying that he got the copy of the certified copy of the sale deed in February and he filed the preemption case in
the in the month of November of this same year.
November. So you are saying it is not within 4 months. Land Reforms Act
It has been filed after
Land
7
Reforms.
months.
You have the act.
Lordship.
It's taken out.
Did not also specify in that plain copy also that this limitation, Lordship.
Huh?
Did not also file limitation application, also did not specify in the plain this limitation.
This is a preemption on the ground of what?
This is on the ground of Lordship. The brief fact is the plaintiff
Brief fact now on the what does he claim himself to be?
stated in the petition that
On
one
the
of the
ground of vicinage or co-sharership or what?
co-sharers.
Then why were you saying 4 months? Co-sharership is 3 months.
3 months. I may be mistaken, Lordship.
All right, you serve and come back.
In the meantime, Lordship, I'm praying for stay this proceeding.
1 minute, 1 minute. Let me just check.
Lordship.
Because of pandemic. Then all limitations were extended by Supreme Court. This is the time during pandemic.
This has been, Lordship, the plaintiff did not specify, specifically.
No, that will be decided in the main hearing as a
Lordship,
issue along
but
with the other issues.
Lordship, the plaintiff did not specify the limitation in that plaint and also did not file this Lordship limitation application, Lordship.
Point you argue when the point of limitation can be taken as an issue in the main suit.
But
why as
Lordship,
a preliminary issue? In the preliminary issue, court found that it was during pandemic, so I am not going to.
Lordship, may I pray, Lordship? Lordship, on the ground of limitation ground, the preliminary issue can be raised, and honorable
Yes, but this is the court has held. This is during the pandemic when the Honorable Apex Court had extended all limitations.
But Lordship, this has been stated by the learned trial court.
So,
But learned trial court, how the learned court got information that this petitioner did not file this on this ground, did not file this.
how is not relevant? Supreme Court did not say how or why. Supreme Court said all limitations are extended.
All limitations, but Lordship, they plaintiff should have specifically stated. Lordship,
it was automatic extension. No, there was nothing that you have to explain. Supreme Court said everything all periods, statutory periods prescribed by law of limitation stood extended.
But plaintiff should have stated in this fact in their petition also. Your
So
Lordship.
this
Plaintiff did not specify this fact. For the reason, Your Lordship, they did not file this limitation.
the court said
Court said, Lordship, but plaintiff
that
did not say.
trial is required and it will be decided in the trial, not as a preliminary issue take down.
But Lordship, when the plaintiff did not specifically stated in that petition that on this ground, they did not
Listen,
file.
one thing, preliminary issue
Yes.
can be decided when it is apparent on the record that this issue can be disposed of without further trial.
Lordship, this
In
is
this
apparent on
case,
the
the court has said that preliminary, as of today, on the face of record, I find that the preemption case was filed when the order of the Supreme, during the pandemic, when all limitations had stood extended by the Supreme Court. So further adjudication of this issue shall have to be done in trial. So that what you are saying, that he has not explained, this is what is the actual thing, he was available, he intentionally delayed. These are matters of trial, you take it at the trial, take down. The court does not find any reason to interfere with the order dated April 21, 2023, passed by the learned civil judge. Learned civil judge, Junior Division 4th Court at Sirampur, District Hooghly, in preemption suit number 20 of 2021. The petitioner wanted file an application for dismissal of the suit on the preliminary issue of and ওখানে লিখুন a preliminary order 14 rule 2b order states as follows. A preliminary issue can be only decided, issue can be decided as a preliminary issue only when the issue, usually when the issue relates to jurisdiction or a bar in the suit created by law, Preliminary issue can be disposed of on the point of law only. And when there is a mixed question of fact and law, such issue is triable. Limitation is a question of fact and law, and hence the learned court did not err in passing the order impugned. Yes, next matter. As a main issue in the suit, it will be decided. Yes.
This is an application for early disposal matter of Miss.
I can't hear you.
My lord, this is an application of.
Isn't it on?
My lord, this is an application of early disposal matter of
what?
Miss Appeal being item number 71 of 2022, my lord, under the appeal court. My lord, the suit is appeal is filed on 27th
You are the
July.
respondent
No, my lord, I'm for the petitioner.
in the appeal.
Appeal, my lord.
In the miss appeal, are you the respondent?
No, my lord, I'm for the petitioner.
In the miss appeal also?
Yes, my lord.
Your injunction also refused.
Yes, my lord.
Sit down.
Madam,
What is the state? Limitation was allowed.
My lord, they are taking unnecessarily dates, my lord, for so many days, my lord, more than 10 months, my lord.
Lordship, on 27th July 2022, the miss appeal will be miss appeal was filed. Then several dates are expired, but not a single hearing happened. And this
Service, it has been served.
yes, ma'am.
Yes, my lord.
Take down.
Madam,
Any application for stay you have filed?
yes, ma'am. Step file করা হয়েছে তো? Yes, my lord. Yes, my lord.
Yes, my lord, to which answer? Which question?
Stay filed, my lord.
Step file. Injunction application also was filed, but no hearing was done. And I pay for my lord to hearing the order 13 rule 1 and 2.
Okay. All right. The petitioner is the appellant in miss appeal number 71 of 2022, which is pending before the learned. Which court is it gone to now?
Additional district judge fourth court. Fourth court.
Additional district judge,
Fourth court Barashat.
fourth court at Barashat. Petitioner submits that although the delay in filing the miss appeal had been condoned, the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure is still pending. Respondents have been served.
Yes, madam.
It is submitted that the respondents have been served with the notice and
Let's say we will only
repeated adjournments have been taken thereafter. Next paragraph. Having perused the entire order sheet, this court is of the view that justice would be subserved if the application for injunction filed in connection with miss appeal number 71
of
of
2022
2022 arising out of title suit number 508 of 2022 is disposed of expeditiously and preferably within a period of 2 months. When is the next date fixed?
next date 18 November October. Let's say if you want
Within a period of 2 months from the next date fixed.
let's say
Thereafter, the appeal shall be heard and disposed of within the next 2 months. As this is an innocuous order and none of the parties will suffer any prejudice if the proceedings are disposed of expeditiously, there is no requirement for service of notice upon the opposite parties prior to disposal of the revisional application. This court has not gone into the merits of the appeal, neither gone into the merits of the appeal, nor into the merits of the claims of the petitioner in the said appeal. The learned court below shall proceed, learned lower appellate court shall proceed independently and on the merits of the appeal upon granting adequate opportunity to all parties. disposed of service of this upon the opposite. You will serve with a copy of this order.
Yes, madam. Yes, madam. I'm grateful. Ma'am.
Yes. Next. Give your name.
Item number? Yeah.
একটু মিথ্যা কথা বলে একটু মিথ্যা কথা বলে আমাকে দেখবি মিথ্যা কথা বলে একটা অর্ডার করিয়ে নিয়ে গেছে রিভিউ পেননি ইয়েস
An application under section 8 and 9.
8
8 and 9 of the Land Records Act.
yes
And that was dismissed by the trial court
that was yes
on the ground that the, as I have not.
so section 8 is dismissed, then isn't it an appealable order?
Section 8 and 9 is not applicable as because division is there.
Huh?
Division.
No. Preemption is an appealable order. Please check up. Rejection of an application under section 8 is an appealable order.
On the ground, there are some grounds.
No, court, the law doesn't say if rejection on some grounds is appealable and on some grounds is revisable. Come back on next week, not this week. Rejection কোথায় allow করেছে তো এটা ঠিক নম্বর দিলীপ কুমার বেরা Which order are you challenging?
The last one, connection I got. That is
You are the
order number
preemptor.
108.
You are the preemptor.
Yes. 108.
Petitioner is directed to deposit balance consideration money within 15 days. Order number?
Order number 108.
Oh, 100. Oh, you have given it like this.
Dated 5th April 2023.
Miss appeal is allowed. What are you reading, sir? I am very confused. Huh? You have not seen your papers properly. This misappeal judgment?
The judgment passed by the trial court.
But there is a judgment by the appellate court also.
Yes, appellate court has because on the ground that I have, when the suit was filed,
So you are challenging an appellate court's order.
not challenging the appellate court order, but trial court's order.
Huh?
Appellate court function is over. Appellate court function is over. Appellate court function is after completion of the appellate court. The trial court at the hearing took place.
So appeal was against, misappeal was in with injunction.
No, appeal against that the money, the total consideration amount, whatever written in the spending, I have deposited part of that amount.
Yes.
And I asked request for the prayer for them to permit me to prove the entire consideration.
All right.
That was allowed by the appellate court.
Then what happened?
Then, my lord,
Remand. After remand,
after remand, my lord, the impugned order is 5th April 2023.
not maintainable, dismiss. It's an appealable order. You come back. The whatever preemption case was dismissed on the ground of non-maintainability. Let this matter appear on. When will you come back?
Thank you, my lord.
You have to come back satisfying me that it is an revisable or it is not. Next week, not this week, থাক। কিছু করতে হবে না।
কওয়া যাচ্ছে আবার।
ঠিক আছে, বুঝছি।
Please, Your Lordship, this is my revisional application from an order of dismissal of the appeal, which was assailed, which was preferred from an order of dismissal of my Section 8 application for preemption. So, my lord, it's judgment of affirmation. The only ground on which it was dismissed was on the ground of limitation. And I am a contiguous plot owner. I am not a co-sharer. Though I had initially filed
4 months from transfer.
4 months from transfer. Now, my case is that there was nothing in the property. And for the first time, I came to learn that masons were there who had carried out some construction work. And immediately within the next month, we had filed the application under Section 8.
And what did the court hold?
Court held that since the transfer dates 3 years prior to the to my application, so my application should go. But it's not humanly possible for.
But I want to know, how did you prove that you came to know on the? You had to prove your.
There has been no
limitation.
trial on that. Only on the ground that I had pleaded that that the deed was of 2008 when we carried out searches and came back. The trial court dismissed on the ground that since the deed was of 2008 and you have filed the application in 2011.
If it is entered in the volume, that becomes notice or something like that.
Yes, but the only thing is that, my lord, I am not supposed to know unless something
like that.
Unless
No,
something
I
takes
forget
place.
now, but it's there.
But because if your lordship sees the
From when will knowledge be counted? I think there are judgments. You come back.
But there are judgments either way. There are judgments either way that, my lord, if your lordship sees the provision once, there's a specific provision for for a co-sharer.
But this is not a.
This is not a co-sharer. I am a contiguous plot owner.
Not notified.
That won't come into the picture because, my lord, I am not a co-sharer, but I am a contiguous plot owner.
Yes, but
where it is
I
4 months.
remember there is a judgment which says the moment it is entered in the volume, the limitation will run from that time. Something like that is there.
Yes, my lord, that has been taken into account in the, my lord, trial court. Now the issue is, my lord, it's not possible for me to, my lord,
That is
as a notice.
the emotional issue. Come to the legal part. It is not humanly possible to know what's happening. I agree.
Yes.
But if the law is settled, law is settled. I'll fix it. You come back with your best of your arguments. Let me also do some homework and see what is the position of law. Yes.
There is no, my lord, which page can I? But may I
Come back.
come back on this? Because, my lord, otherwise I've deposited everything is done. That there's no non-compliance on that score.
No, but the court has dealt with the non-notified co-sharers. Lord, you come back. Not this week, huh? Yes.
The issue is, well, whether Article 97 would be coming into the picture or not.
97 is with regard to non-notified co-sharer.
There is nothing so far as, well, contiguous
US
plot
owner,
save and
because
except
but I
8.
remembered with I've forgotten now. But there
I
is
shall
a
bring all the
judgment,
judgments.
which says that the moment this is entered into the volume, it becomes a
Notice to the
for
public at
public
large. But I shall assist your lordship with all the judgments on this.
Not this week, huh? ডাকো এবার কন্টেম্প্ট নালে এবার মার খাবো তোরা কত এর পরেরটা
Whether the other matter will be taken up, the motion.
কটা আছে হাউ মেনি কন্টেম্পটস আর देयर না মনে হয় না উইল রিচ খালি একটাই তাহলে বস ও রিটার্নেবল কন্টেম্প কটা আছে দাঁড়া 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 10টা জানি না জাস্ট ওয়েট মাইন্ড নট বি টেকেন আপ ইওর ম্যাটার ভাটপাড়া উফ বাবা ভাটপাড়া পাগলা করে দেবে ভাটপাড়া yes call the contempt do one thing you want a little more time
No, my lord, your lordship is keeping it.
আচ্ছা মানডেতে না এটা একটা টাইম ফিক্স করে দাও তাহলে অন্য মামলাগুলো সময় নষ্ট হয়ে যাবে 3:30 হলে আবার মুশকিল
3:30 Monday normally 3:30 is safe.
সেফ না
Monday 3:30 is
4 o'clock রাখো তাহলে মানডে 4 p আছে আছে
no, then no, my junior is saying there's a fixed matter on Monday at 3:30. If your lordship keeps it on Tuesday, Wednesday, any day.
তাহলে
Any day.
let this matter appear on ওটা একটা অর্ডার করেই দিই Tuesday at 4 p.m.
I should bring all the judges.
Tuesday 13 13 তারিখে 4 p.m. এ নেই তো কিছু ঠিক আছে yeah you just see that let me also see all right next all the matters
Compliant.
all
Lordship, Lordship,
আবে এ আবার আরেক ঝামেলা করলাম কি
except 55, Lordship hears me. 55 will be a little different.
item number 2
Lordship, except 55, Lordship, the Lordship matter.
আচ্ছা contempt disposal সব টাকা দিয়ে দিয়েছে
No, no.
then
And gratuity includes the interest for delayed payment, Lordship.
that you file a separate that is automatic file হলেই order ওটাতে তো ওর contest
Lordship,
করার
that
time
will
নেই।
push the petitioners to a second round of litigation. Lordship, these are all senior citizen persons.
Contempt was with regard to the payment of gratuity that is done for interest on gratuity, my lord, 1 second, all orders passed. All be the case.
Lordship, it will create further round of litigation, Lordship.
In a contempt, I can improve in interest. That is not permissible. Take down. Item 55 টা বাদ দিয়ে order করবে. It is submitted by the learned advocate for the Bhatpara municipality that the gratuity amount payable to the petitioner in terms of the order of this court has been released and the learned advocate for the petitioner accepts that the same has been received by the petitioner. Under such circumstances, the contempt application is disposed of, the contempt proceedings are dropped.
Lordship, 2 lines, Lordship. I got
Restrained order, my lord.
The issue of interest was not a part of the original order of this court and hence further decision on this in this regard cannot be and hence further adjudication on the point of interest is beyond the scope of a contempt application. The petitioner is at liberty to take necessary steps in accordance.
There was a restrained order, my lord, that the municipality should not withdraw the.
Permitted in law. It's automatic interest on gratuity. দেখিস নি বল?
Lordship, still,
তারপরে বলো যে the with the disposal of the contempt application, all interim orders are vacated.
We remain grateful, my lord.
Now, Lordship, with regard to item number 55,
Item
Lordship,
number 55 we keep problem.
Lordship, in item number
Where did you go for your summer vacation? What?
no, Lordship, in the
Dada. That's why they son.
My lord will not kindly ask it.
the roof of India.
My lord will not kindly ask it. Now everything is on YouTube. But I could not go anywhere. Now, if my better half watches this, that everyone has gone somewhere or the other, I'll be in scoop.
He should be.
Should be. Yes.
Lordship, in item number 55, Lordship, there was a revised PPO. As such, Lordship, the amount of gratuity has been revised. Lordship, that was issued on 19th of May 2023. Now, Lordship, by the communication dated 24th of May 2023, I have informed the municipality that this is the revised PPO. I am entitled to the revised amount of gratuity.
কতদিনে দেবে? Ask your client, I
That
will
has
fix
not
it.
been paid. I shall take care of that.
Yes, এইটাকে next week রেখে দিই। Next week না, একটা time দিই। Let the in view of the revision in the pay gratuity payable to the petitioner and subsequent revised pension payment order, the court gives 1 month time to the Bhatpara municipality to pay up the gratuity amount as per the revised PPO.
No, no, it has
বলে দিয়েছে
তো আগে vacate করে
no,
দিয়েছি।
Lordship, interim order was passed in all the matters.
However, in view of the revised PPO, about pension payment order be paid within a month. The interim order, however, shall be vacated as already directed. But in the early অন্য order মামলাগুলো মানে as already directed in the other matters.
We are grateful, my lord.
1 মাস পরে রাখো, ওটাকে রাখো। কবে?
একটা কপি দিল
It's Thursday, 6 July at 4 p.m. No, at 4 p.m. All right.
much.
See to it. Don't bring up this. Yes.
Grateful, my lord.
Much of it.
Next. $92.
I am for the petition.
কোথায় গেল? আমাদের ফাইল না, other side. This is Shishanno.
Shishanno, Orko, and Milord Tirthankar.
Do they know that today I will take this matter?
Just now, Milord, Mr. Tirthankar, they asked me whether matter will be taken up or not. I told him, please wait, matter will be taken up.
Do one thing. Do you have their number?
Yes.
Can you please call them? I'll take the next matter. এগুলো সবই তো your matter. অন্যগুলো ডাকো তো। 96 ডাকো ততক্ষণে you please see.
In item number 96, I am appearing for the applicant. This is my affidavit of service.
Now.
My lord, during pendency of this contempt application, some development has taken place.
What is
My
that?
lord, 2/3 salary which your lordship directed, that has been paid, but the gratuity and the leave salary has not yet been paid. As per instruction of the applicant.
I directed upon whom?
My lord, direction was passed.
Two-third pension shall be paid.
Two-third pension.
I did not direct anything else, only two-third pension. Kindly come to my order. The respondent here, this court directs that the admissible dues, namely gratuity, leave salary, and other retirement benefits of the petitioner as well as so and so shall be paid as per the date. Yes. Who is the alleged contemner?
My lord, Mr. Sri Vishwanath Pal, Project Director, District Rural Development Cell, Nadia Jila Parishad.
But is he the person to pay? All right. None appears on behalf of the alleged contemner despite service. Let the Taragalikhun affidavit of service is taken on record. Rule be issued. Returnable 6 July at 4 p.m.
Grateful, my lord.
একটাই আছে yes yeah 92
92, my client has not received any amount as yet.
92 contract. There is a difficulty in item number 92. What has happened, my lord? The entire payment was with the VAT because the period was for 2017. Prior to issue, application of GST, there was a VAT in every work. What has happened? The petitioner was directed to produce the updated return of the VAT, whether he has paid to the state exchequer or not, but till date he did not produce the document showing that he has cleared all his dues. So, my lord, we cannot proceed with the payment. So if your lordship directs us to deduct the value-added tax that was levied in the bill,
all right.
Well, unless and until there is a direction from your lordship, we
down.
cannot. In that case, well, there has to be a separate calculation because
do it within a week and pay.
some more thing is required, my lord, because
The last 6 years they are taking
But-
time. 17
How long to do the math?
the at least fortnight, my lord, for my lord, the
All right. The petitioner submits that if the payment which is the alleged it is submitted on behalf of the alleged contemner that the bill has been prepared and the Bidhannagar Municipal Corporation is ready to make the payment to the petitioner upon deduction of the value added tax. Learned advocate for the petitioner submits on instructions that such payment shall be accepted and the Bidhannagar Municipal Corporation may pay the admissible amount after deduction of the VAT and upon making the recalculation. Amount upon deduction of the VAT and upon making a fresh calculation. Let this VAT বলছে তো তখন তো VAT ছিল
my lord.
let this matter appear on আছে কত
92 থেকে
29th
29.
June
my lord.
at 4 p.m.
But in the meantime, you know, kindly
In the meantime, all payment and accepted shall be payment and acceptance shall be completed.
92 and 93 are same.
Same order.
94 and 95, you know, this amount.
In 95, my lord, payment.
Same order.
In 95, my lord, payment has already been initiated.
That's 362 they have paid.
Total
And
4 lakhs has been paid.
Another minute in two matters, in another matter, minute 1,97,048 paid. But whereas minute my dues are 21 lakhs and minute in another case, minute that is 22 lakhs.
But
So
we are
it's
paying in
needed to be
installments.
paid because of the contempt application.
Item number কত? Document 93
and 94.
Wait for 93.
92 or 93
4 and
same.
95.
92, 93 bolo. 94,
94? What is the case of 94?
But we have already initiated the payment. We are paying in installments because we are paying it out of their own fund because state did not, my lord, provide us any fund. Your lordship is aware of the fact, my lord.
No, that is not true, my lord. Within, my lord, 15 days, they have, my lord, already accepted from government lakhs of, my lord, 4 crores of rupees. And some of the.
And I do not, I have no instruction to that effect, whether 4 crores or 4
For what? For, my lord, construction and, my lord, repairing and payment, because some of the, my lord, my clients.
That is perhaps for fresh projects, my lord, perhaps. I do not know.
Yes, but if you are not giving payment, then
And we are giving, my lord, we are giving in installments. Kindly, my lord, consider our position.
So how much is your due?
My due is this, my lord, I'm coming to that.
এটা কি 94 টা বলছো?
হ্যাঁ, 94 টা বলছি।
দাদা 94 Down here, I got a tower.
55 lakhs 46,727.
And how much have you paid?
Well, 4 lakhs,
No,
3
no,
lakhs, my lord.
2 lakhs 362 they have paid.
Millard will kindly,
Discounted application.
Millard will kindly take the payment slip. Serial number 5 and serial number 6.
Yes.
One is my,
BSP Enterprise and others.
My lord.
BSP,
Two methods are there, my lord.
2 lakh
and my lord, 1 lakh 97.
362.
My lord.
And the payment in serial number 6, my lord,
1 lakh
97. So it's 3 short to 4. 3,000.
আলাদা আলাদা claim, আলাদা আলাদা contract.
Another
How
million,
can you say
14
4?
lakhs 96,771. They didn't pay.
In
We are paying.
1 lakhs 90.
In which one?
In the next one. Both
Five,
are
five.
BSP. Both are BSP.
No.
Well, we are paying, my lord. Kindly allow us to pay the entire amount in installments because, my lord, we have initiated. My lord, if we do not
No,
pay,
initiative, you are not doing any favor.
my
Either
lord,
to me
I
or to
absolutely,
them.
I absolutely bow down before your lordship, my lord, but kindly
Why
allow
should we
us.
be so kind to you? Salt
Well,
Lake Virannagar Municipal Corporation wastes a lot of money on many other things. So go and pay. When will you pay the entire
My lord
amount?
will kindly keep the matter next week. In the meantime, I shall come up with written instruction
Alright,
about
keeping
the.
it on 29,
29.
I expect that it should be paid.
Well, I shall, my lord, I shall.
Entire amount, my lord. Kindly clear this.
Entire amount.
Further opportunity is given to the
এটা কি শুধু 94
Virannagar
95 নাকি
Municipal
সবকটাই?
Corporation to liquidate the amount payable as per the direction of this court. It appears that the alleged contemner seems to believe that by releasing meager amounts in installments, they would be avoiding a willful default. Prima facie, the court finds that the alleged contemner is not taking the direction seriously, and it is more surprising to find that in a contempt jurisdiction, repeated opportunities have to be given for compliance of an order of the court as a matter of course. Let this matter appear on June 29.
My lord, in item number
It
96.
is expected that the money should be paid.
My lord,
In
in
the meantime.
item number 96, my lord, contempt rule has already been issued, my lord. I have the instruction to allege on behalf of the alleged contemptor, my lord. I have got the instructions, my lord.
Petitioner has gone. How will I recall my order? What is the instruction?
Instruction, my lord, the accepting the gratuity, all other payments has
He said
already.
leave salary has not given, nothing has been.
My lord,
No, two-third pension has been given, he said.
yes, 2/3 with including area,
Same order হবে 95
including area.
Leave salary?
Leave salary,
তাহলে gratuity?
gratuity.
When will you release that? ওই
My lord.
ছেলেটাকে একটু ফোন করে ডাকা যাবে? ওটা কত আইটেম নাম্বার?
96.
96. ফাইলটা কোথায়? তো লয়ারকে ডাকো। 1 minute, Mr. Mathur,
Ma'am.
please wait. এটাই কি লাস্ট ম্যাটার নাকি 96 টা? উকিল বাবুকে ডাকো একটু, আমাকে দেখাতে বলছি না। এই দিলীপকে দাও। নাম তো দিয়ে গেছে, কে আপনি কি নিয়েছিলেন? শঙ্কর হালদার হবে হয়তো। অ্যাডভোকেট অন রেকর্ড কে ডাক না। ইয়েস 1 minute, জাস্ট ওয়েট। আর আছে কিছু কন্টেম্পট? ডাকো ডাকো।
Lordship, I am for the petitioner praying for not today, Lordship. The advocate on record has not come to the court today for some personal difficulties, Lordship.
Not today.
98.
You are
as
the?
well. For the petitioner, I'm for 98 as well, Lordship.
ইয়েস, এগুলো সব আমি আর নেক্সট উইকে নেবো না, তো এগুলো সব 29th এ ফিক্স করো।
97, 98.
The 99 or keeps it on 29, my lord. I've missed the brief.
99, 29.
I beg to for the petition. This is my affidavit of service. However, my lord, pendency of the contempt application, the municipality has already passed an order and communicated to us. My lord, just hand over the original which was given. An order of demolition was passed.
The order of this court has been complied with. Learned advocate for the applicant has filed a document which indicates that a demolition order has been passed.
Self-demolition order has been passed.
A self-demolition order has been passed by the Barashat municipality. Stop, nothing remains to be
There's
decided.
something remains. My lord.
What?
In on the off, they have been given 15 days grace period. On the off
That
chance,
I am not going to sit and go behind
the
them.
direction was there to complete come into a logical conclusion, my lord.
That they'll do.
If they don't, my lord, I'll have to come with a
Contempt application, as there is no willful default, the authorities shall act and proceed in accordance with law on the basis of the order of self-demolition.
I'm grateful, ma'am.
Unless the order of self-demolition is either stayed or vacated by a or set aside by a superior forum. By a superior forum.
Ma'am, may I pray for a time limit of the
Contempt
compliance?
application is disposed of.
I'm grateful, ma'am.
Contempt
may
proceedings
I
are.
take the original. I have the
Order
copies as well.
Order fero diye daw.
Let it be kept with the record, my lord.
A copy of the self-demolition order is taken on record. Yes,
I'm grateful, ma'am.
Because in the pendency of these proceedings, an order was passed for removal of encroachment. That order has also been set aside by your lordship in a different writ proceeding. Your lordship might recall on the last.
yes,
So nothing survives in this.
nothing survives in the contempt application in view of the subsequent order passed
Not in this.
by this court in WP. WPA number 12463 of 2023. Accordingly, the contempt is disposed of. Application is disposed of.
Grateful.
Rule হয়েছিল?
Yes, ma'am.
Rule discharged.
May I get a copy? The compliance report. May I get a copy?
What is there? You have that order, no? Compliance order?
I'm not aware of what my learned senior friend is filing today.
I also am not aware. What is there?
No, this is the BLRO's initial inspection report that was done. It's a copy of that.
Keep it with you. The affidavit in compliance filed by the respondent number 4 is taken on record. However, in view of the order already passed in another writ petition in a connected matter, such report has now become inconsequential for the purpose of disposal of the contempt application. Yes.
Brief.
Double. তুলছে না? তো মামলা টামলা করছে, আরেকবার কর, আর মেসেজ পাঠা, কাম টু কোর্ট নাম্বার 19. Yes, ডাকো।
But I'm praying for not today, my lord.
Should I'm praying for a not today.
Not today, 28, 29. পরের মামলাগুলো লস হয়ে যাবে, মুশকিল হয়ে যায়। ঠিক আছে, থাক। যেগুলো অ্যাডজেন্ট হচ্ছে না, ওগুলো পরে দিয়ে দিও। নিউ ফাইলিং যেগুলো হবে আগে দিয়ে দিও। ঠিক আছে, ঠিক আছে। যারা টাইম নিচ্ছে, নট টুডে হচ্ছে, সেগুলো পরে দিয়ে দিও। এই জন্যই বলছি, যাদের মামলা করার ইচ্ছে তারা আগে করবে। নট টুডে, যেগুলো নট টুডে হচ্ছে, আজকে ডাক হয়ে যাচ্ছে, ওগুলো পরে থাকবে। নিউ ফাইলিং আগে চলে যাবে। নিউ ফাইলিং বলেই দেবে, তারপরে মোশনস বলে দেবে, বা নিউ মোশনস, আর এগুলো মোশনস হয়ে যাবে। সাপ্লিতেই তা ভাগ করে দাও। ইয়েস, yes.
31 is my application, Your Lordship. Your Lordship, it's a challenge from an order passed in an execution proceeding where, my lord, the property that has been directed to be attached and sold off is not the property owned by the judgment debtor. Your Lordship, before I take Your Lordship through the documents, I'll just indicate briefly the facts. Your Lordship, there was a contract between two companies. Certain disputes had arisen. Now there was an arbitration clause. Parties went into arbitration. There was an award, and an execution proceeding was filed. Now the property that the judgment debtor was using was on a rent or was on tenancy with me. Now that property was shown as one of the properties in the schedule in the execution proceedings. Now what has happened, my lord? When I come to learn about this, I challenge it by filing an application before the learned court. Affidavits are complete, all pleadings done. In the meanwhile, this company, the judgment debtor, went into CIRP. So by an order passed by the NCLT. So an application was made, perhaps by one of the ex-directors, seeking for a stay of the execution proceedings. In that application,
The RIP personnel has been appointed.
yes, my lord. That's what we've come to learn, my lord. That the execution, the CIRP order was passed. Execution proceed that they had filed an application for stay of the proceedings. Now, in that application, what the court has done is to reject that application and also direct for sale of these assets. Now, what my prejudice is that my application has not been decided. Rightly or wrongly, my application should have been entertained.
You
should have
filed
been-
what application?
My application for amendment of the schedule filed in the execution proceedings. My application was not even considered, like not even heard. So it is later on that I've come to learn that this order was passed, and therefore I've challenged this order before my lords through this application. My lords may just kindly call for the lower court records, and my lord keep this matter any day. And
Why do I need the lower court records?
Then my lord I can address. My lord, Mr. Banerjee is Mr. Shuddhashwata Banerjee, my lord, is leading me in this matter. I My lord, the lower court records, my lord, will show that this application was not taken up and not heard, my lord. My lord, the pleadings are complete. I have already disclosed all of the documents that have been filed before the lower court, my lord, in this application. My lord, my only prayer before my lord is today that good or bad, my lord, right?
1 minute.
Yes, my lord.
Who filed the application for stay?
My lord, one of the directors of the company, my lord, possibly has filed, my lord. We are not the parties to that application.
This property is the office of the company.
It was, my lord. It was the office of the company, my lord. Later on, the tenancy was terminated by a letter, my lord, of 2013, my lord. That letter is disclosed in this application.
Terminated by whom?
My lord, terminated by me, my lord.
It's on page 46.
My lord, I'll just indicate, my lord.
When was it terminated?
My lord, it's a property, my lord, which was initially owned by the Kolkata Improvement Trust. After the Kolkata Improvement Trust sold it to one Savitri Jaiswal, who later on sold it to my father. After my father's death, my lord, 6 heirs became the joint owners of that property. That property was given on rent under a tenancy, my lord, to this company, which was subsequently terminated in 2013. My lord, the document is at page 46.
And then what steps did you take for eviction of tenant?
My lord, no steps, my lord. I'm not. I don't have instructions, my lord.
Then?
My lord, as far as I'm aware, my lord, the possession was handed over to us, my lord.
Possession was handed over to you.
Yes, my lord.
Where is your application before the executing court?
My lord, my application, my lord, before the executing court, lordship will find at
47.
page 47, my lord.
Is in possession of the flat. Yes. Stay of operation of the order dated April 19, 2023. Passed in money execution case number 16 of 2016 up to June 30, 2022. 3. Let this matter appear on June 28, 2023 for hearing at 3 p.m. Service upon the opposite party. It prima facie appears. Are you in the matter? It prima facie appears that during the pendency of an interlocutory application filed by the petitioners who claim to be owners in possession of the property in question, the alleged property has been directed to be sold by auction in execution of a money decree. Award, Deki, execution of an award. Award having a money, carrying a money claim. Yes. No, not July. Before that? 27, 3 p.m. Yes. No. Service, বলেছি affidavit service to file on next. Yes, yes. ওইটাতে না রুলটাকে রিকল করো।
Gratuity.
Serial number 5, ad hoc pension including the area has already been released
What about leave salary?
Leave salary has also been fixed. Leave salary has been reduced.
So contempt is
Gratuity has not been released.
gratuity, project director will not issue.
He has to take steps. Project director.
He is not a contemptor here. So you file a fresh application, I'll give you that liberty. Take down. It to now 96. The compliance report filed by Mr. Mata is taken on record. It appears that apart from gratuity, all other admissible dues of the petitioner, namely leave salary and ad hoc area pension, and the pension including arrears have been paid. But if pension is released, that is also PPO must have been issued.
Yes.
Mr. Mata, then why not gratuity? Huh?
PPO issued in favor of the petitioner.
Kibolam has been released. With regard to the payment of gratuity, the petitioner is granted liberty to approach the Director of Pension Provident Fund and Group Insurance, and necessary pension payment orders may be issued in the group insurance in accordance with law.
In favor of the petition.
I cannot, because he was not the contender here. ঠিক আছে, as it is the specific case of the alleged contemner, that unless the DPP, the Director of a Pension Provident Fund and Group Insurance, issues the pension payment order, the release of gratuity cannot be done, and the alleged contemner does not have any role to play in release of the said amount. Under such circumstance, the bus. Contempt application is disposed of, contempt proceedings are dropped. Yes. Next.
বুঝেই পাচ্ছি। Before my learned friend begins, we have seen the matter in the list. I am the plaintiff in the matter. If he can give me a copy, yes, I agree. But if he can give us a copy, we can go through it. Maybe I will not oppose also. I do not know which order he has come from.
I appeal for the defendants.
If he can give us a copy of the order, application, and it can appear tomorrow, I can just take instruction. পুলিশ হেল্পের অর্ডারটা থেকে ও ওইটা থেকে
on certain acts of illegal trespassing in one of the property, which I have taken physical possession of. I filed a 151 application in that way.
Application by the receiver, at least he should give us copy to the parties. Receiver has no personal interest in the matter.
I'll serve a copy.
What believed that nothing happened? There was no occasion for you to go.
I was informed by one of the defendants, defendant number 7. Upon that information, I was issued a letter. Upon that letter, I had made a police complaint. that there was acts of illegal trespass and theft.
Your complaint did not even mention the police station. How can that kind of an application be accepted by the court? Show me your police complaint.
Page 68. Page 66 is the information that I received from the defendant number 7.
What is this X850 plus XRW?
Probably, Milord, some sort of an internet address had been put, Milord. I am really not aware. Milord, if your lordship comes to the subject line, it is PS Polba, police station Polba. It was issued to.
Where? It's Pandal Polba Road.
No, lordship comes to the subject of
So
the.
you file a fresh police complaint, let the police do what they have to do. You want to go with police? For
With
what?
some police assistance.
My lord, actually, my lord, we had complained.
What are the terms and conditions of appointment of the receiver?
My lord, may I indicate, my lord, it is Mr. Ghosh's partition suit, where, my lord, they claim that she is the, my lord, one of the co-partners in a Mitakshara family. There are certain suit properties. The court appoints a receiver in respect of all the suit properties. I find that in one of the suit properties, there has been a trespass. I complained to the, my lord, receiver. And after that, my lord, the receiver.
The receiver complained to the police?
Receiver complained to the police, and police has not taken any steps. So we have, my lord, been constantly pestering the, my lord, receiver to.
With some
Take it up with the
fresh
police.
inventory has to be done from some fresh inspection as to what is the extent of damage or theft or whatever, and then a report has to be filed probably before the learned court below.
My lord, although, my lord, as a plaintiff, let me say that, my lord, the conduct of Mr. Gupta's client is deplorable. That's why we have gone to court. But, my lord, as far as this matter is concerned, my lord, it's in the infight between us, let not a third party gain, my lord. I always believe that.
That's the exact reason why I complained.
That in the infight between the brother and the sister, the outsider should not gain. If my lord,
Let the police go.
yes, my lord, that's why I said if he gives them, if that is
Also,
that is the only prayer he wants, I'm not standing in the
down.
way.
The petitioner in this revisional application is a receiver appointed by the trial court in title suit number 1785 of 2019. I order dated April 26, 2023. The learned trial court, the learned 12th bench city civil court at Calcutta rejected the receiver's application for visiting the suit property with police assistance. Why you need police assistance? These
are cold storage. My lord. They are
This is a
very
cold
rowdy people
storage.
around, right? It's not, that's
Then
why.
who will pay for the cost of the police?
Cost of the police. Is not a cost. Well, the police will go and make an investigation. There is no.
All right.
अरे पुलिस के की cause दिबी তুই investigation এর জন্য জজ
না পিকেট দেওয়া যাবে না সঙ্গে করে
that
দাও।
picket he can মানে
It appears from the order in view that the learned court rejected the application of the receiver for police assistance to visit the property. To visit the property with police help on the ground that the complaint lodged before the police did not categorically mention the police station. On a bare reading of the complaint lodged before the police station, it appears that the where did you file it?
6th April, I was informed on
Where is the receipt? Where is that complaint before the police?
This has been received by them.
It appears that by a letter from the records, it appears that by a letter dated April 6,
it's 70,
2023,
my lord.
April 6, 2023, a complaint was lodged with the officer in charge, Bandel Polba Road,
Is this your team?
with regard to an illegal trespass and theft of a cold storage at the cold storage, being PM Cold Storage, situated at Moja Gotu, GOTU, Police Station, Polba.
Polba. Go to police station. ওরই তো লোক সব।
The police authorities, however, did not take any steps.
Let's go to police station.
Although the
Go to.
track report of the obtained from the postal department indicates that the complaint was received, was delivered to the officer in charge, Porba Police Station. Thus, the receiver, who is the representative of the court and custodian of the property, has not only a duty but also the right to ensure protection of the property. Thus, having heard the learned advocates for the respective parties, this court does not have any hesitation to hold that the receiver rightfully filed the complaint, and when the before the police station, and when the police authorities failed to take steps, the receiver approached the learned court below for police assistance to enable him to visit the property and make a fresh inventory. The order impugned is set aside. The learned receiver is permitted to visit the locale with prior intimation to the police authorities and to the contesting parties. The officer in charge, Polba Police Station, is directed to provide assistance to the learned receiver during his visit and inventory. The learned receiver shall intimate the police authorities of the date and time
And to make sure that the
of his visit, and accordingly necessary steps shall be taken.
I'm so grateful.
Milord, I believe, Milord, also not only that, but also, Milord, investigate into the allegations.
How
Otherwise,
can I do that?
Milord, that
Police
is
in action, amar nai to.
no, Milord. Milord, that is really the Milord, because now the situation, I'm sure the receiver can go, but Milord, it has to give assistance.
Some direction upon the police.
Some also, Milord, some further, Milord. Otherwise, Milord, this will.
There is no order of injunction.
But that's against only the parties. This is not, well, third parties are, Milord, if they want to enter, Milord. And cold storage, your lordship knows, is very valuable.
This is an incident of breaking open.
Yes, breaking open. So they should also, Milord, look into that.
How in this jurisdiction it becomes a little difficult. Now, ওখানে লেখো that একটা লিখে দাও যে this court observes that once the police authorities had received a complaint from the learned receiver, who is a learned advocate of the court, and the property was in the possession of, in the custody of the court through the learned receiver, steps ought to have been taken.
I'm so grateful.
ঘুরিয়ে পেঁচিয়ে এবার দেখো কিছু আছে ভুল, ওই যে সই হয়নি। কারেকশন হয়ে গেছিল? কত দেরি? ওদেরকে বলো খারাপ হয়ে গেছে তো। Yes. কতক্ষণ ধরে আশায় বসে আছে সবাই।
May I come back tomorrow, my lord, because
কেন বাজে মামলা?
Mr. Probal Mukherjee is
But
leaving.
I am being
but yes,
instructed to appear, my lord.
তাহলে give him his instruction.
33 and 36 are the
No,
identical.
both of the items I have been instructed to appear.
তাহলে 33 and 36, you want me to record an order or you just give the copies and come back? Mr. Jaitodari, I think I can trust you. তাহলে 36 and 30
3 and 36.
33, 36.
কবে রাখবো?
Monday.
তুই একলা করবি না, you also bring leader.
Mr. Roy is there, Pathrapatim Roy is there.
এইভাবে আমাকে মামলা ফিক্স করতে হবে, সময় নষ্ট করা যাবে না।
Monday.
36 and 33 record orders, a copy of the same order will be recorded in both separately. A copy of the revisional application be served upon Mr. Banerjee.
Banerjee, madam. Dutiman
Mr.
Banerjee.
Banerjee. Let this matter appear on 14 তারিখ 4 PM. কিসের মামলা রে?
PM Shan Barashatai Hospital came into the bar, but the matter is identical matter has been referred to the larger bench by the order of this coordinate bench of this court.
Barashat will not be applicable.
Supreme Court settled the matter, my lord, subsequent.
Applicability of the Barashatai Hospital case is, my lord,
Delayed deposit.
delayed deposit.
Short deposit.
Short deposit.
My lord, special bench was constituted, but in the meantime, my lord, matter went up to Supreme Court, my lord, from an order of Justice Basu. That was settled, my lord, that Barashatai Hospital, my lord, that was upheld.
The matter is, my lord,
কোর্টটা কার দেবাশিসের একটা বারাসাত
Yes,
থেকে
yes.
আমি হারিয়েছিলাম।
and that is a retrospectively. If your lordship is of the opinion that it should operate retrospectively since it is a reading of law.
Law laid down.
Yes. Here also the same.
আসুন,
Larger- larger-
ঠিক আছে দেখো। কি যেন দ্যুতিমা, হ্যাঁ
My lord, নাম
দিয়ে
দিয়েছি।
দিয়েছে, দিয়ে দিয়েছে। 4 তারিখ 14 তারিখ 4টের সময়।
14.
আমি বসে আছি, পকেট ভুলে গেছে বোধহয়। ডাকো। আর মাপটা একটু পরে করো, ডাকো।
34, my lord, I am for the petition. My lord, order of the learned building tribunal rejecting my stay application.
Good for you.
No.
Why not?
My lord, only two full points were taken, my lord, before the learned tribunal, my lord. One was that, my lord, that I have already applied for regularization. That was allowed. I have deposited a sum of money.
By whom?
By me.
By which authority?
My lord, the KMC accepted my money. My lord, kindly says.
Acceptance, চালানে জমা দিয়েছে, that is not acceptance.
My lord, this was the single, my lord, this was one of the points. Another point was that, my lord,
What is the extent of deviation? No sanction plan.
no sanction plan.
Come to this law order. The land on which the structure has been constructed is an unassessed land and having no sanctioned building plan. Therefore, the structure cannot be said to be proper for future continuation as opined by the learned technical member. And the question of regularization cannot be taken into consideration in this
My
manner.
lord, page 16 kindly comes to, my lord, page 16. Page 16 is the demolition proceeding, my lord, order by the special building officer against which, my lord, I have approached, my lord. Unauthorized construction of some square feet, my lord. Not, my lord, entirely without sanction plan, I have not done so. My lord, kindly seize, my lord, this.
Come to the first line. Details of unauthorized construction, fully unauthorized building.
My lord, fully unauthorized, my lord. After sanction plan, my lord, a portion has been, my lord, extended. That has, my lord.
No. Partly
kindly-
3, partly 2, and partly 1. Partly 3, 2, 1 constructed by PRs. Property is not demarcated, infringed all KMC building laws. Total unauthorized area is 513 square meters. This proceeding was brought hello.
My lord, against this, my lord, I have went up in appeal, my lord. My lord, kindly
Your point in appeal.
regularization, my lord. Regularization, I have already deposited the money. And my lord,
the premise number that they are showing me, my lord, 30, this is, my lord, Pranavananda Road. My lord, my case is, my lord, that I have, the premise number is wrong. It would be Bridgie Road, 13 Bridgie Road. These 2 points were not agitated, my lord, before the, my lord, in the stay application. Without, my lord, appreciating these 2 points, my lord, not agitated, my lord, not adjudicated upon. Without that, my lord, the stay application has been, my lord, rejected. In a long order, my lord, 10-page order, my lord, these 2 points, my lord, particularly these 2 points I have taken up. That in respect of the premise, there is no existence of the premise, my lord, that they are talking about. 31 Pranavananda Road.
Show me, you didn't file any document in the hearing proceeding?
Yes, my lord. All my points were agitated, my lord. Kindly cease. My lord, kindly, my lord, comes to, my lord, the third paragraph of the first page, my lord, of the impugned order. The appellants have filed this appeal on the ground that the impugned order passed by the learned special officer is not legal. Special officer's building has not considered that the appellants have paid money on such and such date, 37/2022, as per the demand of the KMC in respect of the premise in dispute. And that has not been considered in the stay petition. The appellants have stated that they have a good case to contest. The impugned order shall not be stayed. My lord, kindly seize, my lord, the document.
The KMC lodged a complaint, the FIR. How can you say KMC accepted your money and
Accepted my
regularized?
money, my lord. Kindly seize, my lord.
Accepted. They must have, you must have put it by challan.
After they demanded. After they demanded.
Where is your their demand?
My lord, page 36, my lord, comes, my lord, kindly takes up. Page 36, my lord, is the draft, my lord, I have submitted.
No, where is the demand?
Well, that was not part of the annexure, my lord, in the.
Well, how will they lodge an FIR then?
My lord, and there's a dispute with the premise number, my lord. Kindly consider this, my lord. They are saying, my lord, the 31 Pranavananda Road. My sole case is that it's the whole premise is Bridgie Road and not Pranavananda Road. For Bridgie Road, I have already applied for my lord, regularization. They have accepted the money. They have, my lord, regularized it, and in spite of that, the proceeding is continuing. My lord, that is the dispute of the case, my lord.
No inspection was done.
It kindly takes up, my lord, the. My lord, in page number 16, my lord, the third paragraph.
Collapse at any time. Emphasize the report has been filed. How can there be any dispute with the construction?
My lord, the learned tribunal, my lord, ought to have, my lord, considered my objection, my lord, regarding the. My lord, kindly seize, my lord. My lord, page 3, my lord, page 3 of the impugned order, my lord, internal page 3.
No, they've gone into the facts.
My lord, these 2 points, my lord, they have not adjudicated. They have gone into the other facts, my lord, the facts of they have gone into the merits. My lord, nothing remains, my lord, after this application, my lord, that I admit in the appeal. But, my lord, the difficulties, my lord, these 2 points, they have not gone into. One is, my lord, there is a difficulty, my lord, with the premise number. They have recorded this, my lord, not gone into the merit. My lord, kindly seize, my lord, page 3.
But the engineer has filed a report. From the report, they have demonstrated the kind of illegal construction.
My lord, with respect to the premise number, they have not stated that no, you are wrong, that is the actual premise number. Nothing has been recorded, my lord, in respect to the premise number. And my lord, also with respect to my lord, the regularization part.
Where is the notice given to you?
Notice of, my lord?
Asking the first time that this is a illegal construction?
My lord, the REIT application, my lord, was filed by, my lord, the private respondent herein.
All right, servant, come. Take down. Service upon the opposite parties. No coercive steps shall be taken by the corporation on the basis of the order impugned before this court. It appears to the court that if as any order of if court up to 30th June, let this matter appear in the list on 29th June at 4 p.m. 30th June Corona, 4th July Corona.
Grateful.
No coercive action.
Grateful.
Order impugned, order dated করে দাও ডাকো আমি returnable 4th July না 29th at 4 p.m. Affidavit of service to be filed on the next day. Within 1 month, appeal will be disposed of. Till then, they will not take any coercive measures. I prima facie think of that, but let them come. Otherwise, your appeal becomes infructuous. কি বলো? যা পুরো rampant unauthorized এখন premises number এই number কি বলো? Order dated such and such, passed by such and such. This court is of the prima facie view that if the demolition order is effected in view of the refusal of stay by the learned tribunal, the appeal will become infructuous.
Great.
চলো কি গরম আমার কোড নাকি কোনো কোডেই কাজ করছে না এসি কাজ করছে না মনে হচ্ছে